Court, First Department. Hear, all persons having business with the appellate division draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. We have 8,000 hours of oral argument requested today, or something like that, which unfortunately we are not going to be able to accommodate. But what I ask you to do is when I call the name of your case, please stand up, tell me who you're here for, appellant, respondent, ask for just the time that you need for the most salient arguments that you want to give. If we have more questions, we will ask them. Believe me, we are a hot bench, okay? All right, number one, People versus Perrin Jakubchuk, submitted. Number two, Reese versus City of New York. Sure. Matter of the retention of MM. I'd be delighted. Thank you for coming. Okay. How much time would you like? 7 and 2. Oh, no. even new lawyers only get maybe 5. And respondent? All right, 5 and 4. You know what? Yes, okay, fine. I'll give you 4, 1, and 4, okay? That way you can have time to rebut. Anthony Partners versus Michi.
Respondents, 5 minutes.
Okay, I'm going to give you, and no rebuttal time, appellant?
Rebuttal, 2 minutes.
I'll give you 5, 1, and 5, okay? SJI Renewable Energy versus REV LNG LLC QVW XYZ. Okay, fantastic. Okay, and respondents? I'm going to give you 6 minutes with 1 minute and 6 minutes. People versus Shaim Brunson. 5, 1, and 5, great. Sedo versus Radio City Productions. Okay, I'm going to give the appellant 5 and 1, and the respondents 4 and 4, okay? Capitol Hill 501 versus Capitol Hotel JV. Okay.
For the respondent, 6 minutes.
Okay, 6, 1, and 6. Laferdy versus Aila.
Request 5 and 2, Your Honor. Respondent, 5 minutes, please.
Okay, 5, 2, and 5. People versus Christopher Rivas. I'm going to give you 5, 1, and 5. Leonardo versus Aaron. There is no respondent here, so maybe you don't want to argue against yourself. Do you want to submit, or do you want a minute or 2? Okay, I'll give you 2 minutes. How's that? Okay? Samsung Electronics versus MPEG LA. 5, 2, and 5. Bautista versus 1650 Corp.
Request 2 minutes.
Okay. Draberty versus City of New York. 5, 2, and actually 5, 1, and 4, because you're not going to. 5, 1, and 4 is plenty. People versus Eric Forward. Submitted. Royster versus City of New York. We're going to argue both cases together, okay? Oh, you're right. So we'll, okay. So that makes it even faster. Okay. I'm going to give you 5, 2, and 5. Royster versus City of New York, please don't stand up again, is submitted. And Gomez versus Fremont, which Judge Higgett is recused, is submitted. Okay, so the first argument is matter of the retention of MM. Please come up.
Good afternoon, Your Honors, and may it please the Court. My name is Paige McDonald, and I am here today on behalf of the appellant MM. The respondent and the hearing court has enforced Mental Hygiene Law 939 without satisfying its express statutory requirements that there is a substantial risk of serious harm to self or others as evidenced through manifestations of violent behavior. Today, I ask this court to reverse the July 30th order retaining MM. The respondent did not assert any behaviors by MM beyond a mere isolated incident of MM taking apart a microwave in the confines of his own apartment. 939 makes clear that a situation requiring this emergency admission arises only when there is a manifestation of threats or attempts at suicide or serious bodily injury to self or homicidal or other violent behavior by which others are placed in a reasonable fear of serious physical harm.
So, I mean, he has been released, right?
That is correct, Your Honor.
So his claim is generally considered moot. So why don't you tell us why you think it's not moot in this particular situation?
Your Honor, this case is not moot because MM continues to suffer collateral effects that directly stem from this order.
Would it be fair to say that those collateral effects have not actually occurred? In other words, a claim that it could affect his employment or could affect things of that nature. I couldn't see anywhere that there was that was in fact occurred. If anything, I would like to think that almost, with the exception of getting a gun license, I'm not aware that anyone would have the right to be able to ask about his health.
Yes, Your Honor, that is correct. However, MM faces stigma that has been recognized as significant by the Supreme Court in Vitek v. Jones and has been recognized as having real adverse social consequences.
Are there any specific collateral effects other than what my colleague has mentioned with regard to getting a gun?
Aside from that, it would be the employment and the recognized stigma that is attached to the order.
Well, what do you mean by recognized stigma? What does that mean? Who's going to recognize that that happened to him unless he tells them? The records are sealed, right?
The records are not sealed, Your Honor.
Well, so who would know? Who would know that he had this involuntary hospitalization unless he told them?
It is easily discoverable by hospital staff and law enforcement, and it could lead to forced disclosure when it comes to employment.
Well, that's, I guess, because I think hospital staff should know, right? If somebody's had an involuntary hospitalization, and maybe someone who is applying for a gun license should have to disclose that they've been involuntarily hospitalized. But employment, under what circumstance do you think that he would have to reveal that?
For any careers that have licensure requirements, it's often on the application. As we know, as lawyers and judges, it's on the character and fitness application. It's also on school applications if he chooses to further education for a career opportunity. But even if this case were to be found moot, it clearly fits within an exception to mootness because the issue presented a novel and substantial question as to whether there must be a showing of manifestations of behavior to involuntarily commit somebody under 939. This is especially important for the type of commitment because the statute allows for the commitment under just one doctor's evaluation.
Is that a unique question of law, or is that specific to the facts of our case?
It's a unique question of law to a 939 commitment. Your Honors, I see my time is up. If there are no further questions, I rest my case.
Well, you'll have a little bit of time to respond to your adversary, okay?
Thank you.
Thanks.
Good afternoon, Your Honors, and may it please the Court. I'm Alan Rosinas. I represent the Health and Hospitals Corporation. Your Honors, it's our position that this case is indeed moot, and it's moot because there has to be a showing by the litigant, the appellant here, of immediate and practical consequences of the order, and there just isn't that showing. I mean, he's talking about the possibility, I guess, that he might get a gun sometime in the future, even though on the merits, he bases his whole case on this idea of saying, well, I asked hypothetically if I could get a gun, but I said I didn't want a gun. He doesn't say, you know, we point out in our brief that he hasn't pointed to any particular employment opportunity that's imminent where he's looking for work or.
I mean, in general, right, employers are not entitled to ask about your health status, right? Would be a very, maybe only if you were applying for a job where you needed a gun, might that come up. But normally, we have laws that prohibit employers from asking questions about one's mental and physical and medical health status, right?
I think that's also true, Your Honor. And I mean, you know, that's outside the record, but I certainly, my colloquial understanding is that not every job application or even necessarily every licensing application asks about past mental health treatment or involuntary.
And I doubt that they could, is my point. And so generally saying that it might affect employment is your argument, right? That's not enough to show an exception to mootness.
Right, Your Honor.
And
And
getting
also,
back to your friend's point about not meeting the 939 criteria, I know it can be viewed as moot, but we had a psychiatrist that was treating him, Dr. Gupta, and discussed their interviews and their intake and that whole process.
right.
And they basically characterized it as idiosyncratic when it did show signs of mental illness, correct?
It shows, I'm sorry, Your Honor.
Signs of mental illness.
Right, right. I mean, I think,
I mean, taking apart a microwave and possibly doing something where he could have electrocuted himself or done something else, potential hazardous activity, right?
yes, Your Honor. But,
Particularly when he had paranoid delusions.
right. I mean, the crux of the argument was not just the microwave, taking apart the microwave, it was also the unwillingness to take his medication, and also the fact that Dr. Gupta our expert testified that the type of delusions he has, which are paranoid persecutory delusions that he had at the time, I don't know whether he has them now, but that he had at the time are very highly correlated with violence, and indeed are more correlated with violence than any condition other than suicidality. Now,
So let me just ask you a question about that. So yes, that is what he testified to. He did testify that the doctor felt that MM was a danger to himself and other people, or other people, right? He made that, and the court found him credible, correct?
yes, that's right.
And the patient didn't put on any testimony of his own that would challenge that
Right,
credibility.
no expert testimony contributing it, yeah.
Okay.
And to the extent that he's now arguing, let me just connect it back to the mootness, to the extent he's arguing that there's this bigger issue of whether the final language of 9.39, of the provision 9.39 that's relevant here is applicable, you know, that's not what either side has ever argued in this case, Your Honors. Maybe our argument fails because of the facts not quite fitting that final bit. I mean, we're not saying that they do, but that's what they're arguing. But there's no argument that we can ignore the statutory language. It's just a question of to what degree you can infer, you know, reasonable fear of harm from his conduct. So they're trying to make this a substantial issue by making it broader than it is. This is a very fact-specific issue, Your Honors. So the first and second prongs of the exception standard even are not met, the likeliness of recurrence and the substantial and novel issue. Thank you, Your Honors.
Thank you. You don't have 1 minute if I get there. Now you have 1 minute.
Thank you. Your Honors, the respondent just argued that the reason for MM's confinement is due to his failure to accept medical treatment. Diagnosis of a mental illness alone is not sufficient, nor can a commitment be justified for the sole purpose of medical treatment.
But let me interrupt you just for a second, because the doctor did testify that he found, in his medical opinion, that this met the criteria for involuntary hospitalization, and the judge found that testimony credible. So for us to change that, we would have to make our own credibility determination. We would have to say that the judge below was incorrect for finding him credible, and we'd have to find that doctor's testimony incredible, right?
Yes, Your Honor. However,
That's a tough thing, particularly because your client didn't put on any testimony on that issue.
Yes, Your Honor. That is because MM has no prior psychiatric history. I see my time is up. May I briefly conclude? He has no prior psychiatric history, meaning that he does not have his own treating psychiatric doctor. That is why Dr. Gupta was put up. However, even with the hospital's expert, he still needs to meet the factual predicate of the statute, which he has not. Thank you.
Thank you. Thank you both. Thank you for coming down today. We appreciate your time. Anthony Partners versus Michi.
Good afternoon, Your Honors. May it please the court. This motion should not be dismissed as a non-appealable re-argument, as it was both in form and in substance a motion to vacate and a motion to renew under CPLR 5015A3 and CPLR 2221.
Mr. Michi, you didn't identify yourself, but you are Mr. Michi, correct?
I am Mr. Meach. I apologize, Your Honor.
That's okay. Are you an attorney?
Yes, I am.
Okay.
I'm appearing pro se.
So then you are aware of the history of this case?
Yes,
that,
absolutely.
There was a previous panel that affirmed your contempt.
Right.
And,
But this is,
and I was on that panel.
yes,
And basically, it was in contempt after being appropriately served with an order of the court, a TRO. You then, quoting the decision, in contempt of that order, personally dismantled the sidewalk shed. Am I correct?
right.
So now we're left with a possible inquest to determine the alleged damages to the building owner or your next door neighbor.
Right.
Okay?
So
So in this context, when there's renewal, which you claim there was because you had new facts of ongoing construction in the face of halting construction. I mean, I read your reply brief. So what I'm trying to understand is you also said that you've been watching this from day one.
right.
So what's new about everything?
Well, what's new is the plaintiff's testimony, which we were not able to elicit before the damages inquest incurred, and also his partner's testimony, where both of them contradict each other. The plaintiff says that work came to a complete halt for 7 hours under direct examination. That's what the plaintiff claimed. His partner, when he testified and we confronted him with the evidence that we obtained through the damages inquest, which was the photo, the video, the non-party testimony, the architect's testimony, when we confronted his partner, the partner said that, well, we did the work, but we did it by mistake, and later we redid it. And he said we don't have any records because it was a GC error.
Well,
which
how
the
would
GC
that affect the initial finding that you knew that there was a temporary restraining order and you violated it? That had nothing to do with, later on, them saying something else, had nothing to do with you violating the temporary restraining order. So how could that have been good renewal information?
I'm not here to challenge the restraining order.
I think you are. You sought to.
Sorry, I'm not here to challenge the court's decision, not the restraining order. The evidence that emerged during the inquest is the fraud on the court standard, which we are asking the court to apply.
The evidence that you knew about the TRO and violated?
I didn't know
was a
about it, Your
fraud?
Honor. The court
Well, that
found-
was what was found, right?
But
this-
I
the
disagree. I know the truth. I'm the only one that knows the truth.
100%. But what I'm saying is you're positing evidence of things that happened after that. That can't possibly go to whether or not the TRO should be vacated because it was, at the time, incorrectly issued. That has nothing to do with what happened at that time, right?
The plaintiff obtained an extraordinary amount of relief based on the materially false testimony of delays on the court. They obtained the TRO, they obtained the,
The TRO was for you not to take down the shed. What does that have to do with their action?
because the first order to show cause that they signed, they cited irreparable harm based on delays. So the delays predate the TRO itself.
So this appeal now is an attempt to reverse our decision of January 6th?
This appeal is for the court to analyze at least the fraud on the court standard
Counsel.
based on CPLR 5015.
But I'm trying to understand practically what you're doing here, or procedurally.
If it-
Just bear with me, sir.
Sorry.
We issued an order January 6, 2026, correct?
Right.
We found and affirmed the contempt by the lower court,
Okay.
all right? So you're now here saying that their whole effort to get to claim harm by as a result of the shed coming down and the construction, that really goes to the inquest that you're now attending, where, just bear with me, where you can say, look, they kept building, they weren't harmed, and deal with it that way. But if you're attempting to undermine our January 6, 2026 order, you could only do that, as far as I understand, two ways. You can move to re-argue our order, which you can have a subsequent appeal, and either move for leave to go to the Court of Appeals. So why are you here now?
I see my time is up. May I respond?
Yes, of course.
Okay, so this is not about arithmetic, Your Honor. That we can't have the referee's report decide what's going on. We found the fraud that happened during the we were unable to find before the orders to show cause were decided, and the judge came with an order. And this fraud, based on CPLR 5015, allows us to vacate the orders, and under CPLR 221 to renew based on the fraud. Just because there is a court order doesn't mean that you can't later revisit that court order if the fraud did materially affected the initial court order itself. That's why the CPLR 5015 and CPLR 221 were enacted. Otherwise, there would be no purpose for those two statutes.
Okay, thank you.
You're welcome.
Counsel?
Good afternoon. May it please the court. My name is Rachel Rosenberg. I'm with the law firm of Abrams Fensterman LLP, and together with my co-counsel Stanley K. Schlein, we represent the respondent plaintiff Anthony Partners LLC. Your Honors, I stand before you today on what is frankly a frivolous appeal. While we cross-moved for sanctions below and it was denied, and we did not cross-appeal, at this point today, now that this very same court, which Justice Shulman was on the panel, already affirmed the orders that now appellants are seeking to challenge. On my friend's argument, he says he's not challenging those orders. A 50-15 motion to vacate the order is challenging the very orders that this court affirmed. On his motion below, he styled it as a 30-11 motion to dismiss 8 months after he already filed his answer, or alternatively, a 50-15 motion to vacate based on fraud. All the elements and facts that he talks about that might be fraud, that he describes as halting work or a mistake, were all before a referee, and that was for the referee to determine the extent of the damages. The referee did, in fact, find, after hearing all this testimony that appellant claims is fraud, the referee found that the project was delayed 64 days and awarded
But that's not really before us right now.
Correct.
Let's just talk about renewal or re-argument. So the movant is saying, I found out at the argument that they really weren't delayed as long as they said they were, or that their irreparable harm wasn't as irreparable as they said it was, right? What is your response to that?
This court found that there was prejudice to plaintiff, which is enough to grant a TRO. And this court found that the injunction appeal was abandoned. So the extent of the irreparable harm is just a damage calculation. That is not facts that would change the decision to grant the TRO. Plaintiff appellant admits that there was damages.
Right, I guess. And obviously, he testified that he was watching the property every day. So anything that he could have testified to what he thought was going on at that time, I think he did testify to it. So I don't know why that would be new information.
It's not new information, it's not relevant information, it's not something appellant didn't know at the time, which is why I say this entire appeal is frivolous. And we ask that your honors affirm the Justice Gray's decision finding this motion a motion to re-argue, which no appeal lies from a motion to re-argue.
Did
Any
you
further questions? I'll rest.
Okay. All right,
Your
thank you.
honors.
Your Honors, the information was not, the plaintiff's testimony was not new, was new, actually. The plaintiff's testimony, he testified during the inquest that work came to a complete halt. His partner's testimony that they did 72
Let me interrupt you for one moment, please. You were watching every day, right?
Yes.
So did you testify
Yes.
at the damages hearing? What did you say about whether work came to a halt?
I said I saw everything that happened. I was visiting.
And what was your testimony? Your testimony was that it didn't, correct?
Yes.
And you knew that way before. You knew what your testimony was, what you saw about what was going on prior to the motion, the order, and the hearing, right?
Yes. But like I said, I
So
didn't know
I'm
about
not
any.
sure that because there's a dispute between you, that is anything new.
That is all new, Your Honor. I didn't know that the plaintiff testified, the plaintiff had redid 72 apartments and then blamed me for it. That's not what I knew. I knew that the delays never existed, and whether it's new or not, I think it's all new, but how does that change? They committed fraud by testifying in court that work stopped, when in fact it didn't at all.
Okay, and how does that change the calculation of you violating the order and taking down the scaffolding?
I'm not saying that I should disobey a court order. What I'm saying is.
Well, that's what they found. That's what the first order found. That's why you were held in contempt, right?
I understand, but fraud vitiates everything.
Okay. Thank you. Thank you. People versus Shaim, no, I'm sorry. SJI Renewable Energy versus Rev LNG LLC. Go ahead, counsel.
Thank you, Your Honor. If it may please the court, Peter Stokes of Norton Rose Fulbright for the appellant, Rev LNG Holdings LLC. The trial court respectfully misread the ADR provision at the center of today's appeal, and in so doing has allowed SJI to delay completing its buyout obligation, a process that my client launched in January 2024, more than 2 years ago. The trial court erroneously concluded, in its own words, on page 1920 of the record, that the ADR provision at issue was, quote, limited to the multiple, unquote. Respectfully, that is exactly the opposite of what it says. The ADR provision expressly covers items of the FMV calculation using the plural of the word items, indicating there's more than one. Items, as detailed in pages 31 to 35 of our brief, has a commonly accepted meaning of being a subpart, a component of a calculation, and that's
Counsel?
exactly what it was.
So are you talking about section 11.7 sub A?
Sub B, Your Honor.
Sub B? Okay, thank you. It's a 30-day review period for the books, and if there were any objection, then you would go to your own appraisers, and if there were any other additional disputed items that could not be resolved, that on the FMV calculation, the fair market valuation, then it would go to the independent appraiser. Not that anything else would go in front of that neutral appraiser.
So, Your Honor, the phrase disputed items is used throughout Section B, and it refers back to any disputed items of that FMV calculation. And the definition of FMV multiple itself makes clear that EBITDA is a component or item of that calculation.
But EBITDA is an objective matrix. You can easily find that. The trick here, respectfully, is the FMV multiplier, because you're dealing with several vertical lines with this company. You had, just bear with me, you have natural gas, liquid natural, renewable natural, compressed. I mean, there are three different, and in this industry, while your different company is using cow manure to do all that, which is pretty interesting, I guess, you'd have to look to the other industry, and that's where you get the variables to be able to determine the value of this company. And if someone says, explain to me, master, how in 2 years before it was about $6 million net profit, and the year before it was about $4.2 million, and in the year in question, to be able to determine the value for purposes of buying out the balance of the shares of their interest, it's $36 million. I can send a little red flags about those FMV multiples to justify the objections here.
Your Honor, it's not a red flag because, for many reasons, but Schedule B of the contract itself actually lists a $36 million hypothetical EBITDA achievement for 2023. So the parties were contemplating, I mean, they included this as part of the contract.
Counsel, okay, it's $36 million that year, but then the year before that was 4.5 million. There's got to be something.
That is exactly
That
what...
raises a question, doesn't it? Or two, or several million?
That question is squarely within the realm of the accountants who are empowered to decide this dispute. That is what accounting firms decide every single day. They look at companies' financials, their EBITDA, and they make determinations.
No,
as to
no,
whether...
but here's the problem, right? So FMV calculation is defined as each such determination of the FMV multiple. And the FMV multiple is what the it was connected to the three vertical lines. It's not connected to EBITDA, it's connected to the three vertical lines. And then, if there's a problem with the FMV calculation, which is connected to the three vertical lines of business, then you go to different people who appraise. EBITDA is pretty straightforward. You go to, if you follow GAAP, most people will come very close to it. But the FMV calculation based on the FMV multiple could be hugely different between them. So that's what the document says. So the fact that you're putting in EBITDA isn't in the determination of an FMV multiple or an FMV calculation.
It is, Your Honor.
Show me where. Let's
Schedule...
read it together.
So it's on, I'm looking at Schedule B, Your Honor, of the contract. It's,
right.
Page...
So let's see, what is FMV multiple? What does that mean?
So FMV multiple it's the EBITDA multiple across the entire business.
No, it's not the EBITDA multiple.
No.
It is the fair market multiple based on market comparisons. That's a different thing.
But you can't calculate that without knowing the total EBITDA of the company and the proportion of EBITDA each segment contributes. Okay. So you have to, it's part of the equation.
I don't see that. I think the document says what it says, and since you have two very competent groups of people drawing this up, I don't see anywhere where it says EBITDA. What I see, it says you can send FMV calculation for that.
May I respond, Your Honor?
Sure.
The definition of the milestones itself in section 1.1 specifically says that the EBITDA achievement for the milestones is to be determined according to 11.7. And the only mechanism provided in 11.7 is the ADR process.
But that, no. The ADR process is a limited ADR process, not anything in this agreement goes to ADR process. Okay, so let me let your adversary speak, okay? And I guess I'll start you out with the question, why isn't EBITDA a part of this calculation by appraisers? If the I mean, clearly the parties disagree about the EBITDA, right? So why is this not part of the, not arbitration, I guess, mediation or whatever, send it to the three appraisers, and if they don't agree, send it to another appraiser process?
Sure. That's because the parties went back and forth on that, and actually our client twice tried to put EBITDA into what was going to be included in the appraisal provision, and twice Rev Holdings rejected it. And on page 21 of their reply brief, they acknowledge that.
That's a fair point. However, we know we can't look to extrinsic evidence save for an ambiguity in the provision. So under 11.7b,
Yes.
what goes into the soup with the FMV calculation statement? Because they're allowed to object. Any member can object to whole or part of the FMV calculation statement.
Yes. So there are two main buckets in the FMV calculation statement. One is called company EBITDA, and the other is an FMV multiple. Both of those things go into the statement. And then,
So let me just stop you there. For turning to the former bucket, if it's in the statement, why can't a member object in whole and part to that aspect of the statement?
the member can, and that is exactly what was agreed, and they acknowledge on page 21 of their reply brief that they relented in the end to say that we could object to it. And so we can object to it, and the way that we do that and did that was by saying, when they presented to us an EBITDA amount and an FMV multiple, we said, we object to both. And we don't know actually whether the provision was triggered or not, because we don't know what the EBITDA is. And so then we sent dispute notices about all the things that we disagree with about what they put into their EBITDA calculation. And then we went to the dispute resolution provisions in the LLCA, which are Article 14 and 1515. And so we've done the process exactly as the parties envisioned it, and that is what Justice Barak did in his order, essentially, is made the parties follow their bargain.
So tell me, what is it that you're saying? So I'm looking at FMV multiple, which is the only thing that goes through this process, right?
Yes.
Is the fair market multiple of EBITDA based on market comparisons of entities. That's not EBITDA, right? That's a different number.
Correct. That it's
Right.
a totally different,
right.
yeah, that is a totally different concept. Yeah.
So, while EBITDA, I guess, is pretty straightforward and according to GAAP, those market comparisons are what this agreement seems to be worried about, and why we need 3 different appraisers, and if those appraisers don't agree, and something else. Is that correct?
That's exactly right. And they like to focus on the word items or disputed items or still disputed items. That's exactly where all those disputes come into play. You have valuation professionals that look at this. How do they do this? They see what is a comparable company or a comparable transaction, and then they calculate the multiple that is associated with that comparable company or comparable transaction. So what happens? Is it actually comparable? They say yes, we say no. It's
And the
too big,
EBITDA
it's too
is
small, it's a different industry, it's a different geography, it's a different regulatory system. Already for the
May I
comparables,
interrupt
you have
for 1
disputed
second?
items.
And just say the EBITDA is the same among the 3 market segments, correct? So if there are 3 lines, right, there are 3 different business line.
That's right, and you would have one
So
total.
you have the EBITDA is the same, it's the other number that changes.
Yeah, you
correct?
would have
That
one
would the
total
multiple.
company EBITDA that would be
Right.
allocated across the 3 business lines.
The
and then-
FMV multiples would be the coefficients that you would apply to the EBITDA.
That is exactly right, right. Yeah, and since there are 3 different business lines, that's why you need 3 different FMV multiples. And so again, that's where you're going to get, take those disputes that I just described and now multiply them times 3. And then, by the way, the disputes get even worse because they didn't disclose any information about how they came to their FMV multiple calculations. To do that, what a valuation professional does is they look at a comparable company or a comparable transaction. On the numerator, they look at the equity value. On the denominator, they look at the EBITDA. So, okay, so that now raises more questions. How did you come to the equity value? How did you come to the EBITDA for that supposedly comparable company and supposedly comparable transaction?
And is it possible to go on 2 dual tracks, part of it being do the appraisal for the FMV calculation, but bring a lawsuit for the alleged breach of contract, or?
No, we agree with Justice Brock's finding that this is it's a precondition to the process because first of all, you could go all the way through that process, and if our legal claims, which we believe we are going to win, if our legal claims prove us out, they will not.
I'd be surprised if somebody sued or was sued and
they
didn't
will
think
not
they
have
were
met
going to
any of
win.
the thresholds to actually invoke this Section 11 process. And moreover, it's not only did they trigger it, but to what extent they did. There's actually 2 different levels within it. And then on top of that, I described what valuation professionals are looking at when they are thinking about a comparable company. One of those things they look at is what was the EBITDA of that associated with that company or that transaction. So you actually need to know that before you go into the comparables process.
Okay, thank you very much.
Thank you very much.
You have a minute, counsel.
Thank you, Your Honor. If it may please the court, as SJI did not object in their objection notice that the EBITDA calculation was outside the ADR process. In fact, in footnote on page 11 of the objection, they complained that EBITDA was not was quote used to generate the multiples and that not enough information was provided.
Oh, but they don't say, but they never said, and sure, let's send the whole thing, right? That was never their position.
The point of the ADR process is to promote expediency in closing a buyout, and the use of the word promptly, the use of the word close as soon as possible. The point of this was to shuttle this to an accounting firm that has authority and expertise over EBITDA. And again, you have to know what the EBITDA is. You have to know that as a component of the calculation, because otherwise you can't
cut you off, but you want to get this in if I can. Assuming we agreed with your interpretation of 11.7b and that EBITDA was an item that could be included in the objection, would you still get appraisal relief under CPL Article 76 as of right, or would that still be discretionary?
We have an absolute right to have the contract construed that way, and I'm aware of no case, well, it does say discretion. I'm aware of no case saying a court has discretion to deny relief entirely when the contract unambiguously covers the subject matter and provides that it's subject to appraisal.
Thank you. Thank you both.
Thank you, Your Honor.
People versus Shaim Brunson.
Good afternoon, Your Honors. Elizabeth Batkin from the Legal Aid Society for Mr. Shaim Brunson. The identification of Mr. Brunson by Officer Lazar required...
Let's start with whether the waiver was valid.
There was no appeal waiver in this case, Your Honor. So the primary question I want to focus on is the fact that this case required a Wade hearing so that the defense counsel could probe whether or not the identification of Mr. Brunson was unduly suggestive.
Well, you have to first look into the circumstances of the police officer identifying your client. It was not in the context of a deliberate direction by the police department as we would set up a photo array or a show up or a lineup. He was the investigating detective or the investigating officer at the time, and he was looking at a surveillance video, and he recognized your client, not through suggestion, not through some kind of setup that we normally are concerned about with civilians, et cetera, or victims, because he'd had interactions with your client. Hey, I know this guy. And it was in preparation for presenting testimony to the grand jury. That is not the type of circumstance that would trigger a Wade hearing.
So those were the circumstances that the prosecution alleged in their response to our omnibus motion. But the entire point of a Wade hearing is to allow defense counsel to probe the prosecution's one-sided allegations about how an identification occurred so that they're not accepted as fact. And in fact, the reduced pleading requirements in the Wade context mean that a defense counsel doesn't have to allege any specific suggestiveness about in the identification in order to get a hearing. And that's in recognition of the fact that a defendant typically doesn't have access to information.
But a Wade hearing is only required or is not required if the identification does not come about at the deliberate direction of the state. That's when a Wade hearing is required. So what are you alleging was the deliberate direction of the state, as in a show-up, a lineup, something like that? What are you saying is the deliberate direction of the state that would require a Wade hearing?
Right. So I think that I have two responses to that. And one is that the whole problem is that we really don't know how the identification took place. All we have are the prosecution's allegations. And for instance, we can imagine a situation where what really happened was that another officer pulled up surveillance footage and said to Officer Lazar, hey, you might want to check out this video. This guy in it looks a lot like someone you've interacted with before. Officer Lazar watched the video. I think we would agree that in that situation, we would want a Wade hearing to probe the possibility of undue suggestiveness. And the problem is, we don't know whether that happened. All we know is what the prosecution alleged. But the prosecution in every case is going to allege this identification was squeaky clean, and the point of a Wade hearing is to...
No, are you saying that the facts, that the prosecutor lied about the facts of the identification?
I think that we can't determine whether or not their allegations were fully true, and even if they were true, I think that even on that basis, I don't think that the identification as it was described by the prosecution was necessarily immune from the risk of undue suggestiveness.
How was it susceptible to undue suggestiveness? You gave the example of one officer saying to another officer, you should check out this video, but is there any indication in this case that there was undue suggestiveness?
So again, we would have no basis of alleging undue suggestiveness because, of course, we don't have access to behind precinct walls. And it's in fact, we don't have the burden of alleging any specific undue suggestiveness to get a Wade hearing. We can certainly speculate about possible suggestive scenarios. For instance, Officer Lazar pulled up the video in the middle of the precinct. An officer walked by and said, hey, that looks like Shaim Brunson, that guy you've interacted with before. That's just an example, but it really isn't up to us to come up with suggestiveness, and that really is the basis for these reduced pleading requirements in the Wade context, because of course we would have no basis of entering the precinct and making any kind of allegations about what happened between police officers or when Officer Lazar pulled up the video.
I suspect your friend's going to raise preservation. You want to get out in front of that?
We fully preserved the issue. We asked for a Wade hearing, and that Wade hearing was denied by the court on the basis that there was...
How about his guilty plea, right?
Oh, I don't need to address that, Your Honors. Thank you.
Okay.
Good afternoon, and may it please the court. Faith DeTrolio for the people. If I could just start with the guilty plea very briefly. Defendant did not preserve his challenge to his guilty plea, and it does not fall within the narrow exception to the preservation requirement. And in any case, the factual allocution was more than sufficient to establish defendant's guilt. Moving on to the Wade hearing, the trial court properly denied defendant's motion for a Wade hearing. Defendant was not entitled to a Wade hearing in this case, as the court has already pointed out, because this was not a police-arranged confrontation. The purpose of a Wade hearing is to test the identification testimony for any taint arising from official suggestion during the police-arranged confrontations, and that was simply not the case here.
So in this case, they also seek a reduction in sentence. My understanding is that he pled to second-degree attempted murder. He shot the victim in the stomach during a robbery. He had a history of, I think, 8 previous convictions, which at least 2 were for felony drug offenses.
That's correct,
So
Your
it's
Honor.
not a simple accident here. And the 12 years that he was sentenced, isn't that close to the minimum?
Yes, that's correct, Your Honor. The minimum here was 8 years. The prosecution offered or recommended that defendant be sentenced to 15 years, and the court offered 12. So this is very close to the minimum, as you pointed out. Defendant was also on probation at the time of the crime.
You could have faced 25.
He could have faced 25, that's correct. And if I could just respond briefly to one thing my friend on the other side said about the Wade hearing. The people presented the factual allegations about the basis for the identifications in the ADF. So defendant was well aware of them when he made, or should have been at the time of the omnibus motion, as far as I know. And in any case, he didn't raise these other issues in his motion. The motion court also could have inspected the grand jury minutes if it was concerned about the procedures that took place with the identification.
Wait, what do you mean by the court? Oh, you're saying that the court had the ability, but that doesn't change whether or not the defendant had sufficient information about whether the police officer's investigation, recognizing of the defendant was on behalf of a setup or by the state, right? Can you address that specifically?
Sure. So I just meant that the motion court had more information available to it if it had any questions about what the investigation looked like.
Right. Was there any doubt that that's what had actually happened? Did anyone
No, Your
raise
Honor.
any factual discrepancies that would call that into question?
No, Your Honor, and defendant did not dispute those factual allegations.
Okay.
If there are no further questions, we ask that you affirm. Thank you.
So again,
Time, if you don't give me the time.
absolutely, Your Honor.
Go ahead, Counsel.
So again, Mr. Brunson had no obligation to dispute the DA's allegations in his omnibus motion. Again, that's particular to the pleading requirements in the Wade context. I'd also point this court's attention to the Court of Appeals' decision in People versus Dixon. So in that case, the prosecution also argued that the identification was purely spontaneous. The police had brought a witness on a canvas to see if they saw anyone, and what the DA alleged was that the witness in the back seat, just spontaneously said, "Oh wait, that's the guy. That's so and so."
But that's that's completely different. This is the investigating officer here, right?
Well, what the court found in that case was that a Wade hearing was still required to enable the parties to explore the true nature of the facts surrounding the particular
Because it's a witness being taken around by the state. That's a different factual scenario, and that really implicates whether the state is creating this situation that might suggest a suggestive lineup, right? But here, I don't see it. If it's the police officer and he's just the investigating officer, and he says, "Oh, I know that guy," I don't know how that raises that same level of concern.
I think I would like to briefly address the sentence, if you don't mind, just because I'm running out of time. But
Well, you're out of time, but yes, please
I know
do.
I'm fully out of time. This was Mr. Brunson's first violent felony, and despite his previous criminal history, it's the first time he's received a sentence any longer than 45 days in jail. So our argument is really just that 12 years is more than he needs in order to punish and rehabilitate him in this case. Thank you, Your Honors.
Thank you. Thank you both. Sedo versus Radio City Productions. Counsel, you may begin.
Good afternoon, Your Honors. My name is Stephen Samolsky. I'm with the law firm of Friedman, Levy, Goldfarb, Green & Bagley. In this matter, we represent the plaintiff appellant, Jan Sedo. Now, we submit that the Supreme Court's decision from June 18th of 2025 should be overturned in its entirety. This decision in order ruled that the...
Can you put the mic closer to you? Thank you.
Sorry. Is this better?
Yes.
We submit that the court's decision in order should be overturned, essentially because this motion, which granted the Radio City defendants' motion for summary judgment.
So let's analyze it. On one hand, liability against the city or the NYPD would be if there was some kind of special duty, some kind of representation or promise made to your client with respect to navigating the barricade to get her ticket to some show. And of course, to find Radio City liable, you need special use. That Radio City had something to do with the sidewalk, as we see in most special use cases with driveways and all kinds of stuff like that. There is nothing in this record, unless you can correct me. Let's take the easier one with Radio City. Where in this record did Radio City have anything to do with the barricade setup, which was totally within the discretion and the task of the City Police Department?
Sure. So on pages 737 through 739 of the record, we have testimony from the Madison Square Garden security director, and this portion of his testimony establishes that weeks ahead of the event itself, folks from the Radio City group of defendants would go ahead and meet with the City of New York. Now, at this meeting, they would discuss the event itself, the Tony Awards. They would meet ahead, provide a map, a diagram, a conversation, and at these meetings, the Radio City defendants would then discuss with the New York City defendant that, hey, here's where we would like to make sure pedestrians do not flow. Now, in practice, determining where pedestrians will not flow versus determining the placement of a barrier itself is not so much of a meaningful difference, given the fact that they both implicate the placement of barriers. Even if one were to say, hey, please keep pedestrians out of this area, inherent within that sort of instruction.
Is there any doubt that the NYPD could have said and did say, no, we're not doing it that way, we're doing it this way, this is the way we're doing it? And Radio City and the police department both testified that Radio City could not have said, no, 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 you do it the way I want, right?
Sure.
So, okay. So the fact that they may have said, here's what I'd like in my list of things, doesn't really change the analysis. So is there anything that showed that Radio City made any decisions, actual decisions, about where to put those barriers?
Sure. So when Mr. Arroyo, who was a Radio City defendant
Right.
And a Madison Square Garden security director
Right.
testified, he was asked if Radio City gave a plan for the barrier placement and who determined where those barriers would be placed. His response was the NYPD and our company. In addition to that, we have testimony from the sergeant, who is the sergeant of the barricade section, and this was the city's witness. Now, the city's witness testified that there is a difference between a large event and a small event.
Wait a second, let me interrupt you. Arroyo testified that Radio City would not give the NYPD instructions about where to place the barriers before an event. That's in the record. They didn't. They said, no, we would not do that. So I don't know what testimony you're talking about, but he was pretty straightforward, Arroyo, in his deposition, that they did not give NYPD any instruction. You could look at his deposition testimony.
Sure.
So how do you deal with that?
I would just like to point out that on 737 through 738 in the record, that is the portion of the testimony where Mr. Arroyo did mention that the decision would be made by the NYPD.
And 739, 740 is where he said straight up, that Radio City would not give the NYPD instructions about where to place the barriers before the event. That's the 2 pages before are sort of like a general discussion about how this would go. So that testimony seems to me pretty conclusive that Radio City was not directing where these went. But okay, other than that, do you have anything other you want to point us to?
Sure. I would also just like to point to the sergeant's deposition testimony. And specifically in this portion of her deposition testimony, she mentioned that there's a big difference between a large event and a small event. Something such as a small event, this is, where the officers would use their reasoned judgment, make their best call. But on the other hand, something such as a larger event, they stated, we would typically just stick to what has been requested. Now, to jump back to Radio City's involvement, this request was made in conjunction with both the City of New York and the NYPD. Prior to this actual request for the barriers, it was made as a result of this plan that was both the City of New York as well as Radio City. So here we have the sergeant of the barricade section from the NYPD stating for a larger event, which clearly something like the Tony's Awards or its rehearsal would be a larger event. We have them stating, okay, we stick to the request. We do not deviate from what is in the request for a larger event. But then they stated, distinguishing that with a smaller event, there would indeed be a use of judgment, but not so much.
That still doesn't get you to where the city has some kind of duty to your client. I mean, I'm not going to go through the elements of special duty. You know them well. Where was the reliance? Where was the promise to Ms. Sedo? I promise you, you'll be able to navigate and get the front row in the Tonys so you could see the award better. I'm making it up. You get the point. It's not here. So, is there something here and I'm missing it?
Sure. So I would just like to jump back very quickly and mention that there are two cases that would, reference in our briefs that would hold that where there is an affirmative act of misfeasance, then there is no need to show that there's a special duty or that there's a defense of governmental immunity.
The misfeasance being stacking the barricades so that one leg that was open and obvious should not have been a trip hazard. Is that the misfeasance?
That's correct. In an area that was known to be extraordinarily crowded with pedestrians at a rehearsal for the Tony Awards.
What is your argument with regard to that placing the barricades is a discretionary function of the police department? This was a discretionary function of the police department.
So I would argue that in respect to that point, perhaps in some circumstances where there's a smaller event as elaborated upon by the sergeant, they would indeed use their best judgment and just act upon what they think is best, meaning discretion. But here, it's a larger event, and it's clear that pursuant to the sergeant's testimony, there is a predetermined plan, and that is what determines the number of barricades, the placement of the barricades. This plan was, made in combination between the City of New York.
So are you saying that it was not discretionary but ministerial? Because now I'm looking at, we've got first layer. Is it governmental or is it proprietary? Clearly this is governmental. Drop down, as Justice Shulman was indicating, is there a special duty? We're bypassing that for a moment. Now down to governmental immunity defense. I thought under McLean and its progeny, discretionary action cannot be the basis of liability, no matter how poorly or ill-advised the exercise of discretion is. It's only ministerial acts that may give rise to tort liability. So are you saying that the placement here was so detailed and pre-planned that it fell under the ministerial tent?
Well, I would argue that it's a little bit different than that. I would state that given the fact that it was not necessarily, they were just carrying out an order. I recognize that something such as the placement of a barricade is oftentimes found to be a governmental function.
So what makes this different? As you can recognize, this is what, we've had more than one case on this. So why is this case different?
This case would be different given the active involvement of the private defendant in working with the city to determine the placement of the barricades. And here, based on the sergeant's testimony, and I don't mean to harp on this point too much, but it's clear that at least there's a minimum, at minimum, an issue of fact with respect to whether it was discretionary. Because the sergeant's testimony, I don't mean to overplay this point, it's fairly clear that...
No, I think the Radio City's testimony is really clear that they didn't make those decisions. Sure, they showed the plan, they showed what was going on, but the Radio City representative was absolutely clear that the NYPD was the one who made the decisions. And just, having a general conversation about what the traffic flow is going to be can't possibly be enough to change that. Or at least I haven't found a case. Have you?
With respect to an involvement of...
Yeah. I haven't seen any, have you?
So there are distinguishing cases that we have countered, but with respect to this specific circumstance, we would submit that it's a little bit of a nuanced situation here, which is, distinguishable from others.
Okay,
So with that in mind, I thank the court.
okay. Counsel?
Good afternoon, Your Honors. And may it please the court, my name is Roseanne Palumbo with the law firm of Golden Rothschild for the respondents, known herein as the Radio City.
So I'm going to ask you straight up, do you think that there's an issue of fact as to whether Radio City decided where these horses, the dividers should go?
I don't, Your Honor, and the appellant's speculation that Radio City may have made a decision about where the barriers can go does not create a question of fact where we don't own the barriers. It was interesting arriving here today. There are barriers alongside of the courthouse in the lined fashion and the nested fashion. In the well-developed record, Sergeant Padilla testified that that's how the NYPD delivers the barriers, either in a lined fashion or a nested fashion, and they are right outside this courthouse, 2 blocks in those 2 fashions. This is a governmental function.
They're not Radio Cities.
Exactly.
And what about placement of them?
So again, as Your Honor said, a footprint of the event where traffic is going to flow, where stars, movie stars are going to be, where the red carpet will be laid, does not give Radio City the decision power where these barricades should be placed.
How about the Radio City personnel that were outside?
So personnel outside is just a general presence. All the testimony in the well-developed record establishes that NYPD is security outside, inside is where the radio...
That's not what she's saying caused her to fall, right? The
No.
lack of
In fact...
outside. She's saying that she fell because of the placement of the barriers.
Exactly, Your Honor.
Those barriers are not yours for purposes of the administrative code.
That's right. And interesting, page 237 of the record on appeal, when asked at her deposition what made the plaintiff fall, she specifically said it was obvious that the barriers were not stacked properly. Sergeant Padilla testified the barriers were stacked in the nested fashion pursuant to the instruction of the NYPD barrier section. And if you have no further questions.
No, they're not your barriers, and they're not yours for purposes of the administrative, because normally you would be responsible for the sidewalk abutting your property, but this is not it's a problem with the sidewalk, it's a problem with the barriers, and they're not your barriers, right?
Absolutely, and one final point I do want to add. If we did touch or move a barrier, we would be found in violation of the penal code, in fact, for violating and obstructing and interfering with the governmental function. That's Penal Code Section 195.05. Thank you, Your Honors.
Thank you. Good afternoon.
Good afternoon, Your Honors. May it please the court, Hannah Sorokin for the city. Your Honors, this is squarely a governmental function, controlling pedestrian and vehicle traffic, especially for a large event, is indisputably a government function. Therefore, it was plaintiff's burden to both plead and prove that she was owed a special duty running particularly to her. She failed to do that. In addition to that, this was squarely a discretionary governmental act of the NYPD, so the city is also immune from liability under the governmental function immunity doctrine. So under both of those doctrines, the claims against the city were properly dismissed.
Did she even plead any of that in her complaint?
No, the complaint pleads, on one hand, that the city is...
Was there any pleading in the about a special duty in the complaint?
No, in fact, the complaint does not even plead that the plaintiff here tripped because of the barriers. It just pleads that there were barriers that were the responsibility of the city owed a duty to the public at large, which is not a special duty, and that she fell. There's not even an allegation that she tripped on the barriers. So the pleading is squarely deficient, even though, looking beyond that to summary judgment, the record here, as Your Honors have acknowledged, is clear that there was no special duty.
Small event, large event. Your friend makes a big deal about a large event requiring them to comply with some kind of plan. I think whether it's small or large, the plan is still within the discretion of the NYPD.
Exactly, and I'm glad you asked that, Your Honor, to clarify that confusion. That there is certainly, just a matter of common sense, more planning and preparation that goes into a large event like the Tonys. I'm thinking about it sort of as two layers of the NYPD's discretion. There's the layer, as described by Sergeant Padilla, where Borough Command, the NYPD operations, Patrol Services Unit, all these different units of the NYPD are high-level, with some coordination with the venue, as you would hope to have, where a plan in preparing for generally where the barriers will go, what areas will be off limits. And then there's also a second layer of discretion, which is also, as Sergeant Padilla described, from the individual officers that are actually placing the barriers themselves, where on the sidewalk. She talked about how...
You're saying there's discretion because traffic control is a government function as opposed to a ministerial task?
Yes, traffic control is courts have resoundingly found as a governmental function, and it uses, even just the placement of the individual barriers uses an officer's reasoned judgment. Sergeant Padilla talked about, where they're placed on the sidewalk, both the line and the nested barriers, how close to the curb. Those are all.
What about plaintiff's argument that the police had direct contact with her?
The record refutes that, Your Honor. She herself testified twice, both in her 50H hearing and in her deposition, that she did not see or speak to a police officer on the day of the event. She, I think, saw one officer from afar after the fall that she did not interact with. She did not know if they'd seen it. She described asking two individuals where to go to pick up her tickets, but it's clear from the record those were not NYPD officers. She says that herself. So there's nothing in the record to support that sort of later in time claim that they perhaps could have been, they squarely were not. She had no interaction with the NYPD. No one from the city or NYPD directed her to walk. And also just note that the photographs of the barriers, Sergeant Padilla looked at those same photographs, determined that the nested barriers were safe. If I may just conclude, they were far enough away from the curb. They left significant amount of room, in fact, for pedestrian traffic, really on both sides, but particularly between the barriers and the building. So there's nothing from the city here that establishes special duty, and the city is certainly entitled to governmental function immunity.
Thank you.
Thank you.
Counsel, you have a minute.
I would like to be brief on these points. Regardless of whether or not the Radio City defendants owned the barricades or even had responsibility for placement of the barricades, it is clear that there is at minimum an issue of fact with respect to whether or not they can be held liable pursuant to 7210. Now,
There's a bunch of cases that say that if it's the city's property that's on your property, that 7210 isn't implicated.
So I'd like to refer the court to the Y-Gun-Eng case, and that is a New York Supreme Court case. Under this matter, rather the Y-Gun-Eng matter, there was an NYPD barricade that was on the sidewalk in front of a property owner's building. And as the court ruled under those circumstances, it was irrelevant whether or not it was being used by the NYPD for...
We've got a bunch of appeals cases. Smith versus 125th Gateway, a city signpost is not one, Smirnova, plywood boards that are part of the city's property are not part of don't implicate 720, right? We've got lots of cases sort of saying the other thing. I'll give you 30 seconds to finish.
Thank you very much. I would like to point out that those matters are distinguishable. In the Starrich case, there was no input from the owner whatsoever. Here, at minimum, there was an issue of fact with respect to whether the owner did have input. In the Smirnova case, it's completely different with regard to the fact that there was a plywood board that was affixed to a subway grate. Here, it was not affixed to anything, not for construction, and it was not a permanently placed item. Now, in the Smith case, although there is no signpost here, then ultimately there's no permanent fixture as well. And I thank the court for their time and attention.
Thank you. Thank you both. Thank you, three. Capitol Hill 505 Associates LLC versus Capitol Hotel JV LLC et al.
Good afternoon, Stephen Sinatra. I'm with the law firm of Greenberg Traurig, counsel for the appellants. The appellants in this case are two of a three-member LLC along with the respondent. The LLC is the owner and operator of a Yotel Hotel in Washington, D.C. By the terms of the operating
Which
agreement...
I have to, just as an aside, say it's such a great name. I want my name to be Yotel Motel. Okay. Go ahead, I'm sorry.
I hope I said
I
hotel.
just really,
Justice Scarpola. By its terms, the operating agreement for the LLC gave the managing member sole discretion to do certain things, and among those things was to call capital.
Yeah, but in looking at 3.3.1, which is the operative section in this litigation or in this appeal, yes, they had the discretion, but under certain circumstances, they had what we could consider certain, I don't want to say condition precedent, but certain preconditions. Like before you do a capital call, you have to go out and dig some wells for capital.
Well, I'm very glad you've asked that question because the operating agreement is quite specific in terms of what it is that the managing member needs to do. What the managing member needs to do, and I'd like to actually read the language here because I think it's instructive. If BLDG, the managing member, determines that the company requires additional capital for any necessary expense, and such additional capital cannot be obtained from any third-party loan or reserves held by the company, which may then be drawn upon, then upon 10 days' notice, you can call capital. And what's interesting here, and what is inescapable, is third-party loan is a defined term. It doesn't mean any third-party loan, it means the defined term. So how did the parties define third-party loan? Any loan provided to the company or property owner by a third-party lender. In turn, third-party lender is a defined term. It provides a lender providing financing to the company or the property owner. So these are terms that speak in the present and in the past tense. We know as a matter of law where the parties are utilizing tenses. The court is bound to interpret it consistent with that, particularly where, as here, there's no forward-looking language.
But in 3.31 itself, I hear what you're saying regarding the definition of the third-party loan, but in 3.1 itself, it's cast in the future tense, isn't it? The operative language of determines that the company requires additional capital for any necessary expenses, and such additional capital cannot be. Isn't that cast in the future tense, that particular phrase?
No. It is relating to what it is that the managing member could look to at that time. And what's interesting about that, and again, a very good question that I think is revealing here of the lack of merit to respondent's position here, and candidly the lower court. It also says, which may then be drawn upon, not in the future, which may then be drawn upon. So consider commercial loans. When you have a commercial...
Does that relate to the reserves?
It relates.
Not the loan, but the reserves.
It relates to both, and I'll put it in this context, because there's nothing grammatically that makes it relate to only one and not the other, and the proof is as follows. We all know in a commercial loan that there are terms and conditions under which a borrower can draw upon funds. It's not like they're handing borrowers a pile of money and they can draw upon it for any reason. There are terms and conditions governing what the funds can be used for and when the borrower can draw on it. Similarly, a reserve, quintessential example, is a real estate tax reserve or an insurance reserve. There are terms and conditions under which the borrower may or may not have access to those funds. So it's very revealing when it says may then be drawn upon. We're talking about funds that a borrower could look to and take and apply to the necessary funds that are being sought at that time for the
And
purposes
here's
of
the
the LLC.
problem with your argument, right? If your argument were true as a matter of law, then this next sentence that says, as the date of hereof, initial lender, which is the lender that you think is the third-party lender, is a third-party lender. You absolutely wouldn't need that if all you were talking about is that one lender. That would make that whole sentence superfluous. And I can't understand why you would put that in if the only lender you were talking about is that lender. That's your position, is the only person I could go to was a third-party lender. To me, is not as a matter of law what this says, particularly because of that sentence.
Well, Justice Scarpool, let me see if I can overcome your skepticism in that regard. What the parties were pointing out was that is the lender, that is
It's not
lender.
the third-party lender,
But bear
it's
in mind-
a third-party lender.
But this is the answer to your question. Okay. At any given time, the members of the LLC could go out, refinance, get additional loans. So what it contemplates is there could be other lenders who would then be, and by the way, any loan over $100,000, and there were loans, capital
major
costs for over
decision.
$30 million here, millions of dollars, would have to be approved by the members. So the concept that you're pointing to, who was the third-party lender at that time, it also means that the parties were contemplating those loans could be taken out. Those loans could be added to if they were consented to by the members, and by the way, the existing lenders,
I'm not
that there could
disagreeing
be
that
other
that could
third-party
be-
lenders.
I'm not disagreeing to that, but what I am also saying is a reasonable interpretation of this is that before you come back to me for more money, before you make a capital call, not one, but two, but three capital calls for me, you have to see if you can at least convince the third-party lender to let another third-party lender come in. I don't think that that's an unreasonable interpretation, and that would give effect to the statement, as of the date hereof, the initial lender is a third-party lender, meaning you can go back to that lender, or you can go see if somebody else wants to lend you money, and my initial lender agrees to it, which the initial lender had to do. That's not an unreasonable interpretation of that section.
It is precisely because it actually leads to absurd and commercially
I
unreasonable.
don't know how absurd that is,
Well, I
to
can
say,
illustrate
before
it.
you come back to me for more millions, because maybe I'm not of the same level, I only have 25%, you've got 50, right? And you've got way more money than me. Before you unilaterally make a capital call, and you can't even be charged with breach of fiduciary duty unless a higher standard, you have to go out and try and get money from someone else. I don't think that that is necessarily an unfair way to interpret this.
Well, the impracticality is this: at any given time that the LLC needs money, it could need the money immediately. If it could need money for
But there's
debt
no-
service, it could mean for any of those purposes. So,
But there were no attempts made, though. There were no attempts made. So it's not like of the 5 capital calls, one of them was an emergency, 2 of them was an emergency. It appears that no attempts were made to get loans from third parties.
there is, I don't believe that there is anything in the record that says that no
We're
attempts
not
were
there
made.
yet.
But let's bear
This
in
is a
mind.
pre-answer. This was a pre-answer motion to dismiss the second amended complaint. Based on the case law that I know you're familiar with, you construe everything in favor of the plaintiff. And the question is, as pleaded, did the plaintiff give a fair interpretation to 3.3.1, as my learned colleague tried to suggest to you here?
It's not, the answer is, we believe no. It's the province of the court to interpret as a matter of law any contract among the parties here. What we're saying is that that is not a fair interpretation of the contract given the tenses and the language that's being utilized. And the reason why it's absurd and commercially unreasonable, because in any given instance, you have an operating LLC. In any given instance, there could be funds that are needed for the LLC. The timing of that could be critical. So
Why didn't you consider a short-term facility?
But I'm going to answer the question in this fashion. How many applications would have to be made by the managing member before one could say that funds cannot be obtained?
We're not at that point yet, right? Because obviously, if we sustain the complaint, that is a completely different argument. The only argument is this as a matter of law an unreasonable way at this pre-answer motion to dismiss, an unreasonable way to interpret this section?
Well, I'd like
and
to
I
quote
know
the
you
First
think it
Department.
is. I know you think it is.
Well, would you agree with me that at this procedural juncture, the only way you win is if the document is only susceptible to one reasonable reading, and it's the reading that you're proffering?
Yes, and this is where I'd like to quote the First Department. A contract should not be, this is the First Department speaking, a contract should not be interpreted to produce a result that is absurd, commercially unreasonable, or contrary to the expectations of the parties. When you have competing interpretations, as we have here, ours is the only one that actually is harmonious with the rest of the provisions and makes sense under the circumstances. Consider for a moment.
No, you're way past your 6 minutes.
Thank you.
Thank you. You have time on rebuttal. Counsel?
Richard Feldman for the respondent. The interpretation provided by the appellant, though interesting, does violence to the express terms of 3.3.1. As Your Honor pointed out, it talks about cannot be obtained from any third-party loan, or, the disjunctive or, not and, reserves. There's nothing to indicate the reserves are only those enumerated in loan documents. In fact, necessary expenses relates back in its definition to the budget.
You know what my problem is, I will say, with this second amended complaint is the declaration. I'm not really sure why you posed it as a declaration. It seemed to me that the only way that would work is if you're trying to get around the heightened standard of the duty that the managing member owes you, because I don't understand why you just didn't plead a breach of contract.
And what would be the remedy unless we sort of declaration? We can't hold the managing member for money damages unless there's willful or fraud. So there's money damages is out. We need a declaration of the rights of the parties. That's why it was framed as a declaratory judgment
So
action.
you're not seeking money damages?
We are not. We're seeking a declaration that it was a breach by the managing member to disregard the requirements of 3.3.1.
And what would your remedy be?
It would be to subordinate all money put in through
So
these
that's
capital
money
calls.
damages.
No, no,
That's
no.
exactly, that is my issue. I mean, this is a pre-answer motion to dismiss and no one raised it, but I will say that you are trying to get around the heightened pleading burden that you have that you agreed to by pleading this as a declaration, because then you get money back.
No, Your Honor. What
You do,
by them putting in money through these capital calls, they've shifted the risk and the benefits of the operating agreement. 5.1A describes the windfall of how the money is distributed. First, it goes to the members who meet the calls on behalf of the ones who don't, plus interest at the rate of 12%, quarterly compounded. So there's a huge windfall to them. That shifts the benefit and also the risk. Assume there's only a certain amount of money, assume the triggering event is a sale, and they get all their money back before there's a distribution of initial capital. Now they've put my client, a passive investor, behind all of their money. That shifts the risk of the investment. That's not what this provision would allow.
But you're really seeking to declare how they should behave
Yes.
as a managing member.
That's correct.
And that they can't unilaterally decide to make a capital call without meeting the conditions of going out and digging wells.
Correct. They could have gone back to Deutsche Bank. In the pandemic, Deutsche Bank was giving loans, forbearance agreements, loan modifications, but they wanted a pay down.
Well, I guess this goes to your friend's workability argument, that
Correct.
what are the contours, if any, of this obligation to go out and seek a third-party loan?
New York law implies, says there must be good faith in every contract. Does that mean they had to hire Jones Lang LaSalle to place a mortgage? Perhaps. Does that mean they had to go out to the 3 to 5 major lenders in this sector where you have $110 million lent for a hotel in Philadelphia and see what financing is available?
I guess your friend's,
That's down the road, though.
I know, it's down the road in terms of good faith performance.
I guess your friend's point is, we contemplated this by employing the definition of third-party loan, which is in the past tense, which giving, if we would give it a plain reading, the definitional section, these were loans that had already been procured.
Except 3.3.1, the actual provision at issue talks in the future, cannot be obtained. That's crystal clear. The plain meaning of that is it has not yet been obtained. Cannot be obtained. His interpretation does violence to that. The interpretation of the respondent is reasonable. As long as I've met the reasonability
I like the way you softened your voice
motion
there.
to dismiss.
He's beating that section up, and you're being reasonable on it. Okay.
And as long as I do that, this court must affirm the lower court. And Judge Borak, who said during the argument, I've practiced in this area for 20 years, this area of the law. And this is a finely crafted provision by the appellant's law firm. I commend them for it. And it makes perfect sense, in fact, when read in conjunction with 6.4.5, which says for major decisions, you have to sit down and talk. Before you shift the risk of the investment, before you shift the benefits, the members, have to sit down and decide what to do. And they could veto. If Deutsche Bank said, for the forbearance, pay us $5 million, which would be split ratably, they didn't want to do it, perhaps, that's a decision they could make, but then they can't make a capital call. That's the consequence.
You have a minute.
The cannot be obtained refers to loans that are in existence at that time and whether or not the borrower has the right to draw down on the existing lines of credit. The cannot be obtained refers to reserves and whether or not the borrower is allowed to invade those reserves for the purposes for which the capital calls are being made. It's very clear. There's nothing ambiguous about it. And one of the questions that was put to respondent that is very telling here relates to the remedy. I'd like to discuss that for a minute. The remedy they originally sought was money damages. We moved to dismiss because there's an exculpation clause here. Money damages aren't available. As courts have said, courts will not come to a party's aid when it sits idly by, accepts the benefits of another's performance, knowing it has the grounds to object, and only later asks the court to declare the performance void. Well, isn't that what happened here? We began making capital calls in November of 2020. In December of 2020, we made 1, 2, 5 capital calls. All the while, they're claiming you're not following the procedures that are set forth in this operating agreement. And they wait until the last capital call, $34 million goes in, 8 months after the last capital call, and they say, well, this wasn't in accordance with the terms of this agreement. Clearly, and now what are they looking at? Well, they were denied the ability to recover money damages. So now they're coming up with a theory that, well, this must be an ultra-virus activity. Well, ultra-virus activities or activities, it's to some degree esoteric and relates to corporations. It's where there was no authority for the corporation to act in that capacity. Translated here, that the managing member had no authority, but Section 6 it's set forth, bear with me 1 second. It is set forth in the operating agreement that the managing member expressly has the authority and the power to call capital here.
Oh, under the circumstances set forth in the operating. No, I don't think that.
There's
on any, without any limits to it?
There is a bedrock principle of law, okay, that if the parties express in their agreement that a violation of the agreement in the clearest terms would be void or void ab initio, well, then under those circumstances, the argument could be the capital cause were void. But that's not the case here. And what's of particular interest, again, and the courts have commented on this, where the parties have utilized that language elsewhere in the agreement, the presumption is they didn't utilize it in the other section of the agreement, and that intentionally. So here,
Counsel, again, we have your brief. We've read them both. We've read them carefully, as you can see. Thank you very much. Laferdy versus Avia.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant. Let me make this simple. Obviously, if it's a medical malpractice case, I'm out. If it's a negligence case, I'm in. I didn't write this brief. I read it like you called. I cannot for the life of me figure out how this certification.
Well, your client, when the family retained counsel and presented the pleadings, and they sought a certificate pursuant to CPLR 30-2012A, which was required for medical malpractice actions. So that's right up front on 52 of the record. And then when you look at 192, 193 of the record, which is the operative medical physician statement for medical review unit, which is what you're holding your hat on to establish that the doctor messed up. Dr. Vila messed up in either the information with respect to when the last episode occurred for the defendant driver and various other things, that somehow in getting it wrong, that's negligence rather than medical negligence. So tell me, Mr. Isaac, when you look at the form in its totality, where they're seeking a medical opinion, and the language is clear on the form, even if it's somewhat simplistic, that isn't something that would trigger the 2.5-year statute of limitations.
So the answer, Judge Shulman, is it's not my claim. I absolutely admit the form says what it says. There is a provision in there, paragraph 10, which you've read, which talks about a medical opinion. That's not my claim. My claim is that this doctor knew, it's in his records, not mine, knew 6 months before that you cannot certify an individual who's epileptic unless they're seizure-free for a year. Let me tell you exactly what I mean. Go to 138 of the record. This is the November 7, 2018 record 6 months prior. Paragraph 3. I'm going to read it to you cold. I reviewed driving privileges in the state of New York and explained that he should not be driving, meaning the patient, because of current unprovoked seizures. The parents and the patient understood, although he was disheartened by this new information. Key sentence. I explained that New York State requires a 1-year seizure-free time period prior to granting driving privileges. Now go to the record you're referring to, 148, paragraph 1, 2, 3, 4. And there's one word I want you to focus on. Interval visit, interval history, second paragraph. I last saw him on January 23, 2019. Here's the key sentence. He reports, that's the word I want you to focus on. He reports no further seizures since his last visit, and his last seizure occurred on January 4, 2010. I'm not here if there's a diagnosis. This isn't a diagnosis case. This
That
is
is
a
not
reporting
the
case.
only thing that's on that form.
I agree.
And that is not the only thing that the DMV looks at when they decide whether or not to give him. He makes medical judgments on that form. And that's what you've pled. You didn't plead that we should take out that one line. Nowhere did you plead that. Nowhere until this motion did you decide that we should take out that one statement. But it's impossible to take out that one statement because he makes a lot of judgments, medical opinions on the form that the DMV used. And so I don't know how you could separate that out and say that that's negligence. Filling out that form was filling out as a doctor. That one statement is not the only part of it.
As my prior counsel said, let me try to switch your opinion as well.
Yes, of course.
Is it okay if I go over my time? I asked for permission.
Yes.
Okay.
Go ahead.
And I'll be fast. I have 2 minutes afterward. Your Honor, my only point is that is not my claim, okay? My claim should be limited to the reporting issue. That's what it is. And if you read the Davis case, which we rely on the duty issue, they talk about the fact that when you're considering the propriety of a complaint, you don't look at the terminology. The question is whether or not you have a claim that's recognizable in law. So I will stipulate to you, my adversary can tell you, we will not be making claims dealing with his diagnosis. We're not saying that he did anything wrong with his diagnosis. We're not saying all we're saying is that he shouldn't have put in that form that he was seizure-free when he wasn't in his own
Sir, so we're talking about the May 15th, 2019 form?
Yes, 192 to 193 of the record.
Okay, so it's 2 pages. Mine's 2 pages. Is yours?
Mine is 2, yes.
Okay, so which box or boxes in particular are we talking about? I think it's on 193, I think is where we get
Box
into
4.
the guts. Okay.
Date of last episode, incident associated with condition, June 2017. That is demonstrably not true.
But does that phraseology of question 4, so is that susceptible to medical judgment as opposed to when was the last episode of X specifically? This is a little, could this be read a little broader, the date of last episode / incident associated with the condition? Because as you know, for negligence purposes, it has to be purely ministerial as opposed to something which bears a substantial relationship to medical treatment or diagnosis.
I'm not going to go much off my tongue, so I have 2 minutes, but if you look at 193, paragraph 4, and look at 148 after interval...
I'm sorry,
148, okay? Interval history, paragraph 2, he reports no further seizures since his last visit, and his last seizure occurred on January 4, 2019. He's saying he's having a seizure. So you can parse that all you want. I just don't think on a 3211 motion I should lose as a matter of law. I'm sorry for going over.
May it please the court, I am Martin Adams, counsel for...
I want to give you your time, so give me a second.
Okay.
Okay, now, please.
May it please the court, I am Martin Adams, counsel for respondents. I respectfully request that the order of the trial court be affirmed. This is a medical malpractice case as plaintiff pleads it, and both the wrongful death and the medical malpractice statute of limitations had expired, and appellant only focuses on med mal, which was expired.
So let me ask you this. The fact that he checked off that box that was a an alleged, because maybe his notes were wrong and not the box, we don't know, right? That wasn't what caused, that one thing didn't cause him to get his license back, right? There was the whole document is what causes him to get his license back, and the whole document is filled with medical opinion, correct?
Correct, yes, yes. And
So it's impossible to say because of one misstatement of fact
correct. In
that
fact,
it's negligence and not malpractice.
Correct. In the Blyther case, which is a Court of Appeals case I cited, the Court of Appeals held that failure to take a proper medical history is malpractice. Failure to elicit all information pertinent is medical malpractice.
Well, sir, this isn't a failure to take a complete history. This is, you took the history, but you didn't properly place that information which you already obtained onto this form, right?
Which is basically a failure to diagnose, or insufficient diagnosis, or erroneous diagnosis. What appellant is basically saying this was an erroneous diagnosis. In fact, and the appellant relies heavily on the DMV form. He cites box 4, which was the date of the last incident. I cite in the same form, page 193 of the record, box 10, which says, in my medical opinion. In fact, the form on the prior case, the DMV instructs the information provided must be based upon a current examination performed by your physician.
Didn't he fill out this form when the driver was there for an appointment?
I don't know if the driver was actually there at that time, but this was clearly part of the medical care that the Dr. Aila was rendering for the patient over the past 3 years.
There's a hypothetical here, and if you know based on your understanding of the relevant VTL provisions and the motor vehicle regulations, we have the same exact form as we do on 192, 193. The only difference is in box 4, the appropriate information was placed in there. I think the last, well, at least the last, as reported by the patient, was it January of 2019 was his? Okay,
Appellate said
so let's say January 19 is in that box, in box 4.
Yes.
Under the applicable VTL provisions and Department of Motor Vehicle regulations, would that information in that box, in and of itself, require the denial of the application to renew, if that's the right word, reinstate the license?
No. The answer is no, it would not require denial of the license. I refer this panel, honorable panel, to 15 NYCRR 9.3. A driver is fit for licensing if there's no loss of consciousness within the last 12 months. That's just one of the 3 possibilities. Here are the other ones. Same regulation. The loss of consciousness within the last 12 months is okay for giving a license if the loss was because of a change of medication confirmed by a doctor, or the doctor says the condition will not interfere with the safe operation of a vehicle. Within the last 12 months, there can still be a license with the permission of the commissioner, of course.
And that box was checked off, correct? The box where it says the patient's condition will not interfere with the safe operation of a motor vehicle?
Yes.
And he could have checked off, this could have been wrong, but in 10, he could have said, any of this could have been wrong. But if he says, in my medical opinion, the patient can do that, can drive an automobile, the patient's condition will not interfere with the safe operation of the motor vehicle, that is the pertinent part, right? What the doctor is, because that's what the DMV wants to know. If in my medical opinion, this person is safe to drive.
Yes, and under, as I say, 15 NYCRR 9.3, a unconsciousness within the last 12 months can still give the patient an ability to drive with the permission of the doctor, and that it's safe to do so. And of course, also with permission of the commissioner of DMV.
Oh, thank you.
Thank you.
Let me see, what did I give you on? I gave you 2? Yeah, okay.
So, Your Honor, let me deal with that question. I'm not sure he's right, but let's assume he's right. If we're talking about mixing and melding, okay, on a 3211 motion, if I have a certification from the doctor 6 months earlier where he says in his typewritten records that I told this patient that he couldn't drive because New York State requires that he be symptom-free from epilepsy for a year, and I have a mistake for whatever reason with respect to when the last seizure was, because it wasn't in 2017, it was 2019. I don't think it's fair in that situation in a 3211 motion to say because he also made a medical certification that this person could drive, that's conclusive. That to me doesn't make any sense on a 3211 motion. Maybe on a 3212 motion you can do that, but not here, because those are inconsistent positions internally, and it has nothing to do with Brian Isaac. I'm looking at his records only, that's all.
That's fair, but ultimately what we're concerned about here is this common law negligence or is it medical malpractice? And so if whatever goes into the soup here involves medical judgment or skill, then aren't we on the med mal side of the ledger? And
The answer to that question is 100% right, but it's not my claim. I'm not going to fight with you on that because I can't win.
But you're line 4 of page 193.
That's correct. This is not a medical diagnosis. It is a mistake. It is
So
a
how does
factual
that
mistake.
lead to the causation of the accident?
Simple.
That's not why the DMV, that mistake isn't why the DMV gives him his license. It's because the doctor says, I think he can do this.
Judge, Your Honor, I have a right to explore that. I have a right to ask this doctor, listen, if you knew that this patient had a seizure in January of 2019, would you have signed that form?
That's a medical opinion, isn't it?
No, it's simply a fact, goes to my case.
You're saying, do you have any case law or anything that suggests that if the doctor knew that you must be symptom-free for 1 year, you can never even if the patient convinces you clinically and through all the tests that he took through MRIs and scans and the medication he's taking, that he's symptom-free for 6 months rather than 12 months.
Gentlemen, I'm going to answer your question directly. 138, this is Dr. Avila's note. I'm reading it. It's not me. I'm not interpreting it. I explained that New York State requires a 1-year seizure time-free period prior to granting driving privileges. Word for word, not me. That's the defendant doctor. I'm sorry I went over my time.
No, thank you. Thank you both. People versus Christopher Rivas.
Good afternoon, Your Honor. May it please the court. Maylee Picard, pro bono counsel from Davis Polk on behalf of appellant Christopher Rivas. Your Honor, I'd like to address the 2 pieces of Molyneux evidence that were improperly admitted in this case. The people's entire theory of admissibility for this evidence can be boiled down to improper propensity arguments. According to the people, Mr. Rivas must have intended to kill Mr. Salix outside of Tonic because he's the kind of person who brandishes guns or threatens people with guns when he gets angry. They admit as much in their opposition brief, and they said as much to the jury in their summations during trial. Now, as I said, there are 2 pieces of evidence that were at issue here. First, the trial court impermissibly permitted Ms. Jesuari Nunez, Mr. Rivas's girlfriend at the time, to testify that he threatened her with a gun the day before the killing. Second, the trial court permitted the prosecution to cross-examine Mr. Rivas about a party in the Bronx several weeks before the killing, where he allegedly told someone that he had a gun. Neither of these incidents have any factual or causal connection to the killing for which Mr. Rivas was connected.
You don't think that go ahead, Ken. You don't think that motive for what seems like the slightest just a touching of a companion to show motive would not be a good Molyneux exception?
Well, Your Honor, here, there is no comparable motive to the prior instances to what happened outside of Tonic. They're essentially—
So wasn't it the prosecution's theory that he shot the man in the face, which is an incredible response to someone touching someone else because he was jealous that the other guy touched his girlfriend? And in fact, I think he testified something about her breast being out. Right? Don't you think that that goes to his motive for what would seem a very incongruous response to a very slight issue?
Well, Your Honor, I think what that boils down to is Mr. Rivas's character and whether he's the kind of person that would do something like this.
It's about motive. Why would someone do this, right? Because he testified that it was an accident, correct?
He testified that it was an accident.
So isn't the prosecution entitled to dispute that and show that it was his motive was because of jealousy of someone touching his girlfriend?
But Your Honor, these prior instances were in completely different factual circumstances. They involved completely different people at entirely different times. And that's why it wouldn't be.
The fact that his girlfriend's not answering the phone and he texts, "Pick up the phone or I'm going to kill someone"?
Even in that situation, when he was texting his girlfriend, there's no connection between the someone he was texting about and Mr. Salix outside of Tonic. And that's exactly what the Court of Appeals said in People versus Telfair, because there, the Court of Appeals held that the mere fact that someone might do something in the past doesn't mean that they would do something in the future or at a later date. And here, what the government is effectively arguing is that because Mr. Rivas felt threatened by someone in the past and was willing to get angry then, because of some ratcheting up of behavior, he'd be willing to go further at a later date. And
But
that
is
is
it
a character
important that
argument.
the anger, as it was tethered to this particular individual, which here the prosecution's theory was he grossly overreacted because he was so protective of that individual?
Well, Your Honor, here, the victim was an entirely different person, and that's a key distinction because the incident even involving Ms. Nunez, the cases that the people cite to in support of why it would be a Molyneux exception involve the same perpetrator against the same victim. That's an entirely different set of facts. Here, when Mr. Rivas threatened Ms. Nunez the day before, that involved an altercation with her. That didn't involve being protective over her. That doesn't speak to his intent outside of Tonic that day. And that was the hotly disputed issue, and it was highly prejudicial to Mr. Rivas in that moment because the jury was also incredibly focused on this evidence. They sent multiple notes about it during their deliberations. It was the last piece of evidence they asked for before they returned their verdict. So clearly this weighed heavily on them, and that is what makes it so prejudicial. That coupled with the fact that the people raised this so frequently and so vociferously in their summation at trial, they effectively told the jury, and I quote, that Mr. Rivas gets angry. He likes to brandish his guns when he gets angry. That is a character
But he gets up and
argument.
testifies. He doesn't know anything about this gun. He doesn't know. He didn't know how it went off. It was wholly accidental, and you're saying the prosecution had no ability to counter that narrative?
The prosecution has the ability to counter that narrative.
And
with
why
admissible
wouldn't showing why he did what he did, and two, that this isn't the first time that he's touched a gun or understands how to use a gun, why aren't those going directly to his motive and to dispute his excuse that it was accidental? Why is that not competent evidence for that?
It's because the incidents involved different people at different times and different circumstances. He threatened someone in the past. That does not mean he had the motive or intent to kill someone in the future, and that is the key difference. That's the connection that we're missing here and why this evidence shouldn't have been admitted and why this case should be remanded for a new trial. Thank you.
Good afternoon, Your Honors. May it please the court. Addison Esley for the people. As Your Honors have pointed out, this Molyneux evidence was highly probative on defendant's motive and intent in shooting Salix. They both demonstrated defendant's jealous and controlling nature over his girlfriend, and that shed light on defendant's reaction when a man on the street, or a man outside this bar rather, touched his girlfriend, helped his girlfriend up, talked to his girlfriend.
What about your friend's argument that the Molyneux evidence related to threats he made to her directly, whereas here in the prosecution, he shot a third person?
Your Honor, I don't think that would distinguish it to the point of not being admissible. It's still probative on his intent. It may go to the probative value of that if it's with the same person in the past. But really what the Molyneux evidence is getting at is that defendant explodes with anger and jealousy at his girlfriend in certain instances, and that sheds light on his response when that occurs in this case. And so even though these prior instances had nothing to do with Salix, the victim here, it still does shed light on defendant's state of mind as he shot him. And as Justice Scarpula also pointed out, the people were entitled to refute defendant's defense of mistake here, where he testified that he did not intend to shoot Salix. The people were then permitted to introduce evidence to refute that defense, Your Honor, which by going to the intent and the motive here, the Molyneux evidence does.
Do you want to address the other issues raised?
Yes. So for the 730 issue, Your Honor, the trial court properly accepted these uncontroverted reports by experts that found defendant competent to stand trial, and therefore it wasn't an abuse of discretion for the court to proceed without further hearing. Defendant's own counsel did not request a hearing, the people did not request a hearing, and there was nothing in the record suggesting that the court
And the defendant refused to be interviewed, right?
And the defendant refused to
Have we
be.
ever said that the court has the authority to force someone to be interviewed if they don't want to be interviewed?
I'm sorry, could you?
Have we ever held that the court is required to force someone to be interviewed if they don't want to be interviewed?
To my knowledge, no, Your Honor. There's no requirement in the CPL that the judge here should have issued further commands beyond the examination report, and defendant refused 3 times to show up for his scheduled examination, and therefore there was no abuse of discretion by the judge here in determining to move forward.
He was the one who requested it too, correct?
Defense counsel requested it at the arraignment, Your Honor, that's correct. And then moving on to the excessive sentence, Your Honor, defendant's sentence of 23 years to life was warranted here because, as Your Honor pointed out, this is a dramatically outsized reaction to a man simply helping a woman up from the street after she had tripped. Defendant approached him, pushed him, and then as this man who was unarmed backing away from defendant then pulled out a gun and shot him in the head.
And this is
then
on video.
callously walked away. I'm sorry?
And the crime is on video.
And of course, everything's on video, Your Honors. If there are no further questions, people ask that you affirm. Thank you.
Your Honor, even if
Got it. Okay, go ahead.
Even if the prior act's evidence could show that Mr. Rivas may have been jealous, all it shows is that when he does that, he threatens people. It doesn't show that he had
Give
intent
a
to kill.
limiting instruction on the Molyneux evidence?
Well, Your Honor, the court gave a limiting instruction during Ms. Nunez's testimony that focused on Mr. Rivas's identity. It said only that because he may have possessed a gun at a prior time does not mean he would possess a gun at a later time, and that speaks nothing to the high prejudice that would come with submitting propensity evidence. So that was an insufficient limiting instruction.
Was there an objection at the time to that limiting instruction?
There was an objection to her testimony as a whole when defense counsel moved for a mistrial.
You're saying that the limiting instruction was insufficient. Was that objection made at the time?
The defense counsel later requested a limiting instruction on Molyneux evidence generally, and I think even then the court can't unring the bell of hearing of how prejudicial it is for the jury to hear that evidence. And he did preserve the objection to admitting the evidence in the first place.
Right, but not to the limiting instruction.
At that instance, no, Your Honor. But
did you want to address the 730 issue?
Sure, Your Honor. In that case, Mr. Rivas was entitled to a physical examination by 2 medical examiners, and he did not receive that. They requested it, and the court unilaterally said that he was fit to stand for trial, despite him not being reviewed by 2 examiners as he was entitled to.
What if he's refusing?
In this case, he only refused 3 times, and there was never an attempt to get the court to order an examination, as there likely should have been.
Is there any requirement that the court order him to do it?
Well, in People v. Torres, 194AD, 2nd 488, it was an instance where the defendant had refused to be examined on numerous occasions. It went far beyond what happened here. There was no attempt to seek any guidance from the court to have him examined, and that in itself violated his rights in that instance. Thank you, Your Honor.
But didn't the doctors go over the records and reports and found him fit?
The doctors examined the reports, but the language of 730 requires a physical in-person examination. So simply reviewing old reports that are not necessarily up to date and don't speak to state of mind at that time would not be sufficient under the statute. And that's why he should have been entitled to a physical examination.
Thank you. Thank you both. Thank you for your pro bono service.
Thank you.
Leonardo versus Aaron. Yes, come on up.
Can you refresh me my thought? I think you said I had 2 or 3 minutes.
2 minutes, yes. I'm going to start you now, okay?
Thank you very much.
Go ahead.
Number 1, the appellee and her past present attorney have not appeared at this hearing today, and they never filed a response to my appeal or reply to my appeal. Secondly, there has never been any established facts or conclusion of law of the appellee's net worth statement or in any inquest hearings. What was submitted by the appellee and her attorneys, past and present, was a net worth statement with no receipts attached, a tax return with no 2020 signature on it, and no signature. One second. Oh, with no signature attached to it, which is a direct violation of Domestic Relations Law 236B. Thirdly, I would ask that this court vacate, reverse the lower court's decision in its entirety with prejudice.
Thank you.
Welcome.
Samsung Electronics versus MPEGA.
May it please the court, William Adams for Samsung. On its third attempt, MPEG convinced Supreme Court to permit it to slash Samsung's royalty distributions in half. These are the royalty distributions that it receives for MPEG's continued sublicensing of Samsung's patents. Our brief set out 3 legal errors, each of which independently warrant reversal. I'd like to focus on the first one, the vote's failure to satisfy the contractual 80% supermajority requirement. Section 6.11 of the AAL required that a reduction of Samsung's royalties be approved by, first, 80% of current licensors, and second, any group of licensors that collectively received 80% of the royalty distributions over the prior 12 months.
Were you part of the group that received 80% of the royalty? Did you receive, let me start with, did you receive royalties the preceding 12 months?
Samsung and other terminated licensors, yes, received royalty distributions over the prior 12 months as they were entitled to do so under Section 7.32 of the AAL, that's at page 71. And
So you're saying you were in part of that second group, and that second group, they didn't get the 80% majority?
the group of licensors referred to in this, what I refer to as Romanet 2, was the 25 licensors that voted that MPEG permitted to vote. And those 25 licensors did not receive at least 80% of the royalty distributions over the prior 12 months. The only way Supreme Court and MPEG were able to conclude that 80% threshold had been satisfied is by importing language from Romanet 1, which references current licensors, into to make it modify and limit the royalty distributions that are referred to in Romanet 2. That language simply doesn't exist. The Romanet 2 refers to the royalty distributions over the preceding 12 months without any limitation or restriction. The Supreme Court and MPEG now on appeal fails to consider all of the royalty distributions.
So your license is part of, even though you're not part of the agreement, they're still using your license.
Absolutely correct, Your Honor. We're still Samsung is still sub-licensing its patent rights.
How long will that happen?
It's not in the record, Your Honor, but patents have a 20-year term, and so we know, it's
So for 20 years, they'll be.
yeah, it's not imminent. It's not imminent, but because patents expire and sublicenses cannot be renewed, and because this vote looks at the preceding 12 months, this is not a static situation. The period of time of which the royalty distributions you're looking at will evolve over time as licenses drop out, as patents expire, as the 12-month period changes. And so just because they weren't able to meet the contractual requirement of the 80% supermajority threshold in March 2024, doesn't mean it's an impossibility, an impracticability, a workability problem. It just they couldn't meet the burden that's set forth in the contract as it exists under the plain text.
So in your view, sir, the skirmish isn't about the word licensor, it's about royalty distributions?
Correct, Your Honor. You do not need to determine whether Samsung or other terminated licensors remain capital L licensors or capital P parties under the contract. All you need to determine to reverse here is whether the 25 licensors that were permitted to vote received 80% of the royalty distributions over the prior 12 months. They did not. If you consider all of the royalty distributions from the prior 12 months, only if you consider a subset could they possibly do so.
So it doesn't matter whether it's current licensors or just licensors that include the previous licensors.
Correct, because the royalty distributions in Romanet 2 is not modified by either the current licensors or the licensors or the licensors who were permitted to vote or any other limitation on royalty distributions. It is the entirety of the royalty distributions that were distributed to the pool in the prior 12 months. And if you consider all of those, the 25 licensors that voted here got less than 60% if you consider the breaching distributions, and actually 40% if you consider the non-breaching distributions under this court's prior determination. So both of those numbers are obviously less than 80%, and so under the plain language of the contract, we don't think it met. There's also
I'm sorry to cut you off. I just white lights on. Assuming the word licensor, licensors does have a material meaning in that section, your friends from their brief, and they'll correct me if I'm wrong, seem to draw a distinction which they ground in different provisions of the agreement between a licensor on the one hand and an original licensor who has terminated the agreement and is no longer part of the pool. Does such a distinction exist in your view? And if it does, what's the distinction between those two groups?
Sure, there are, the AAL does refer and does distinguish between original licensors, and Samsung was an original licensor, and others licensors or parties that later join the pool. But we don't think but under the definition of party, which the distinction matters for the purposes of party, but also those are the first two subsets of the definition of party. The third subset, the definition of party, is a catch-all, and it refers to any party or entity that signs the agreement. And so certainly Samsung has signed the agreement, and it therefore is a party. And the definition of a licensor is those parties that have executed this agreement. So there's sort of the short answer is the belt and suspenders approach in the definition of parties and licensors. We satisfy the third subpart if you were to determine that matters. It's certainly not unambiguous in their favor that we're not a licensor. This is on our motion to renew, a motion for summary judgment. And so for them to prevail on the definition of party or licensor would have to be unambiguous in their favor, and it's certainly not.
Thank you. Counsel?
Good afternoon, Your Honors. Garrett Beeney on behalf of respondents. May it please the court. Your Honors, the Commercial Division applied the plain language of this agreement and held Samsung to the bargain that it struck. As we've discussed, these patents last for 20 years. The things change in the market. Prices may change for infringing products, technology changes, and the existing licensors need the ability to change the agreement, and that's what Samsung agreed to. To your question, Justice O'Neill-Levy, it very much does matter that Samsung is not part of any group of licensors. That is the group that gets to vote on this. That is the group whose distribution matters. If we actually look at the language of the—
Is that right? Because they're committed for 20 years. So if they decide not to re-sign, right, don't you think that they should have some ability to object to having their license fees, that you're using their license, right, for 20 years? So, or you're sub-licensing their license for 20 years. And why, if it was, why would it doesn't say any group of current licensors that collectively receive 80%. It just says, and in one, it does say current. In two, it doesn't. That is, to me, seems clear that there are two different groups of people. Why not put current?
Well, let me answer what I understood you wanted to ask, two questions.
Yes.
First of all, Samsung leaves the program, so they no longer have the right to join in the administrative committee under Article 2. And these are people that meet regularly, discuss the market, discuss what's going on, so people need the ability to adjust. And because you've terminated, you don't get higher rights.
Oh, I agree, but if your sublicense is generating 50% of the revenue, why would you agree to having, because you're not a current member of the group, why would you agree to have your license fee cut in half?
Because
if it's 70%, if your license is the big license and all the other signers only produce 10%, you're saying that 10% can increase their value, the way that you're reading this agreement, because they are 80% of current licensors, they can take all the money, and the person and the group and the licensor who was generating 80% of the money gets cut in half. That, to me, doesn't make commercial sense.
It does, Your Honor, because when you sign these agreements, you have agreed that if you terminate, you leave the fate of the program in the hands of the people who are there.
Well,
And
then
that's
why
plainly-
doesn't it say any group of current licensors that collectively receive 80% of the royalties?
Let me get to that if I may, but I will get to it in a bit of a roundabout
Okay.
way. So the provision that we're talking about talks about any group of licensors that collectively receive. It is clear that Samsung and the other terminated licensors are not licensors as defined in the agreement. Nothing could be clearer. If we look at section
And I think, sir, to cut to the chase, I think your friends are willing to concede that, at least for their prime argument. Their point, as I understood them, was we have to look to the next line down, the royalty distributions, and the royalty distributions as a whole, which may include people who have left the pool. We still have to factor in that and the total amount of royalty distributions in ascertaining whether the 80% threshold was
I
satisfied.
think that's not right, respectfully, Your Honor, because it talks about the distributions to a group of licensors. It's the distributions to the group of licensors, and Samsung is not a licensor. What it wants to do is to have one set of people in the numerator of the fraction and a completely different set of people in the denominator of the fraction.
No,
And
I
the
think it says you have to get both. You have to get A plus and. It's an and.
No, I'm talking.
Right? But doesn't that make sense?
No,
Because the
it
current.
doesn't, Your Honor, because I'm talking only about Ruminette 2.
Okay.
You need 80% of the distributions to licensors. Samsung is not a licensor, number one. What it would like to do is to have in the group that's in the numerator of that fraction, people who can vote. There's no doubt they can't vote. In the record, they said they're not a licensor. Mr. Shin testified that they're not a party when they terminate, obviously. So they're not in the numerator because
May
they
I
can't.
just interrupt you for a second and say it's your view that even though I don't want to be part of this group anymore, I've already committed my license for 20 years, and I generate 90% of the money for that pool. My license, although I'm not a current licensor, my license, which is still in, generates 80% of the revenue. That the 80% of the current licensors can cut my revenue in half? That's your view?
That has to be the way this is read, Your Honor.
Okay.
And it has to be for at least a couple of reasons, if I may continue to
Sure,
answer.
just answer this, but then I've got to.
Certainly I will. If Samsung's reading about this provision is correct, it reads it out of the agreement. They can't vote, and nobody disputes that they can vote. But once the terminated licensors ever receive 20% of the distributions, if you include them, then this provision has no meaning.
No, because you get more licensors. You get other people to join in so that they are not.
But
so that you get 80% without them.
No, Your Honor.
That's the whole point.
No, Your Honor, that's not the math.
Okay.
The math is that if the terminated licensors ever have 20% of the distributions and you include them, you could never use this provision, even if everybody agrees to the amendment, because only the people voting are in the numerator, and that's undisputed. But anytime you get any single group and you include non-licensors, the terminated, in the denominator of the fraction, you'd never be able to use this provision.
It's
and you
not
can't read it
it's
that
a
way.
plus. It's a plus, not a numerator. And it's 80. It's
a fraction,
80%
Judge.
and 80%. Allocations shall require the approval of a supermajority consisting of 80% of current licensors and plus any group of licensors that collectively receive 80%. So you may have 80% of current licensors, and the way you get the second thing is to get more licensors in who are generating revenue so that it is fairer to the people who leave the group but are still contributing the most amount. I'm sorry, let me let you answer.
Your Honor, but if I can,
right?
if I may,
I
I'm
don't, yeah,
sorry.
yeah.
May I respond to that?
Sure, of course.
So we're looking at a fraction. We're looking at 80%. On the top of that fraction is people who can vote. What Samsung says is on the bottom of that fraction is people who can vote and all terminated licensors. If that was correct, and the terminated licensors ever hit 20%, this provision would be read out of the agreement. The rights of terminated licensors are in Article 7, and this clearly can be changed. And yes, there is in provision Romanet 1 the use of the word current, but nothing in this record tells us what that means. It could be an errant word, and this program has been existing for 13 years. There's no evidence that they ever in any vote, ever considered terminated licensors' shares in applying this provision for 13 years.
Sir, I just had one question for you. If we agree with your reading of Romanet 2, what is the material difference between Romanet 1 and Romanet 2?
Romanet 1 would be the vote of 80%, having nothing to do with distributions. And then Romanet 2 gives current licensors, the licensors, who may have a larger share of distributions, more of a say than they would on a one-person vote. And
Okay,
that's
but they're both, under your reading, both 1 and 2 are made up of current license, quote-unquote current licensor.
Yes, Your Honor, and as I say, there's nothing in the record that tells us what current means in Romanet 1. You certainly can't apply, the doctrine of looking to what is in Romanet 1 to say what Romanet 2 means, because we know what Romanet 2 means by the word licensor. It's clearly defined as not including Samsung, and so their distributions are not included. And if you look throughout the agreement, the word licensor is used to mean current licensors.
And may I have just one question? What about section 6.1? And that distinguishes between licensors and current licensors.
It does, and as I say, Your Honor, there's nothing in this record that tells us why they use current in the beginning, but you can't use the argument that current is in the beginning to overrule what is the clear definition of licensor in the rest of the agreement. And it also talks, to further address the question, if I may, Your Honor, it also talks about a group, a supermajority consisting of, that must be the people who can vote. It's not a supermajority consisting of people who can't vote, and so you can't include the distributions in the denominator, both because they're not licensors and because the rights of terminated are in section 7.2, and because this is a group consisting of people who can vote. And the commercial division was entirely correct in giving Samsung the rights that it agreed to for these lengthy programs.
Okay, thank you.
Your Honor.
Counselor, you have 2 minutes.
Thank you, Your Honor. My friend said that Romanet 2 talks about the royalty distributions to the group of licensors or to the group of current licensors. It simply doesn't say that. It talks about the royalty distributions over the prior 12 months. There's a temporal limitation for sure, but there's no limitation on the recipients of the royalty distributions.
What about counsel's argument that you're not a licensor anymore?
Whether we are a licensor or not is not relevant for this issue, because there's no limitation on the royalty distributions that you're looking at. He's trying to import, I think, current licensors from Romanet 1 or the group of licensors from the beginning of Romanet 2, but that doesn't make sense. We know as a matter of cardinal contract construction that the use of current licensors in one provision implies a different meaning when it's absent from the second provision, and there's no reason to move something from the front clause to the back clause. It wouldn't actually, if you said, if you rewrote that and said any group of licensors that collectively receive 80% of the royalty distributions to that group of licensors, that would always be 100%, because the group is the same. That any group of licensors is referring to who votes in favor of the agreement. Here it was these 25 licensors of the 29 that were permitted to vote, and they did not. It's undisputed that they did not receive more than 80% of the royalty distributions over the prior 12 months. And it makes sense to have these two different distinctions. Romanet 1 ensures that these changes to allocations, which are significant changes, have the support of the vast majority of the current licensors. That makes sense. Romanet 2 serves a different purpose. it ensures, regardless of the group that's voting in Romanet 1, that the vast majority of the economic interests in the pool are supporting this amendment too. And as Justice Scarpula, as you've been saying, Samsung has a substantial continuing economic interest in this pool because it is allowing MPEG and is required to allow MPEG to continue to sublicense its royalties. So that's why it makes perfect sense to have this two-tiered process, and the second tier was not established. It's undisputed based upon the plain language. Respectfully ask you to reverse.
Thank you. Thank you both. Bautista versus 1650 Corp. We only have one side on this one.
Good afternoon. May it please the court. Kyle Silverstein of Cascone and Clubfeld for the appellants. The critical issue is essentially whether or not plaintiff can rely on a theory of recurring condition in this case. We submit that they cannot because the cause of this leak that caused plaintiff's slip and fall was out of defendant's control. These were two children who lived in the apartment above plaintiff that overflowed their bathtub. It then went down into plaintiff's bathroom apartment ceiling, causing a leak. This was the only time this has ever occurred. Any other leaks would just be...
But didn't plaintiff complain about leaks 5 times before this incident?
Regardless of whether or not plaintiff complained about the leaks, it's for a recurring condition to apply, it has to be it can't just be a general awareness of the leak. In this particular case, there was evidence that there was a shower pipe broken 4 months before that defendants repaired. But that's not even the cause of this particular leak. This particular leak was by two children who lived in the apartment above plaintiff, overflowed their bathtub in the ceiling. It then went down the floor and into the ceiling.
But the 5 complaints were made like 2 months before the incident. So it's not just the 4 months or 4.5 months after you fix the pipe leak.
Again, though, the plaintiff, there's no determination what caused those leaks. The answer here is that because the children caused the bathtub
That's your view. Maybe it's not his view. That you're saying we have to accept your view of what caused the accident, right? But that's not the plaintiff. The plaintiff's saying this is a reoccurring leak, and the fact that the water came down doesn't necessarily have to do with those kids. It could be a million different things.
That's a fair interpretation of it, yet I would suggest, or I would submit to you that plaintiff at the point of the opposition of summary judgment should have put more to say that beyond just speculating, oh, well, this was a leak. Again, the Court of Appeals has been clear. It's not just the general awareness of a condition. It has to be the particular cause. It's a specific cause here, is the children overflowing.
But doesn't plaintiffs also argue that the repairs weren't done properly and that the overflow from the children exacerbated the situation?
If it were the negligent repairs, that wouldn't be a recurring condition. The critical issue is whether or not plaintiff, because if he cannot rely on recurring condition theory, there's no constructive notice. The record is very clear that plaintiff went to the bathroom, I believe, at 9 p.m. at night, and there was no water on the floor, and then he woke up in the middle of the night, went to the bathroom, and there was water on the floor. This brings up a whole other issue of whether or not a recurring condition theoretically imputes a duty to a defendant to patrol private citizens in their apartment. Essentially, the court below is putting the onus on the defendant to go and make sure that there is no potential chance for a leak to occur. That would require the defendant to go to each apartment and say, hey, is anything going on here that I need to know about? That would be asinine, essentially. And so for those reasons, we request this court to reverse the lower court and find that there was no chance that the recurring condition could apply. Thank you.
Thank you. Draberty versus City of New York.
Good afternoon, Your Honors. May it please the court, Jonathan Popolo for appellants. All we know in this case with respect to the accident is where the motorcycle came to its final rest. There's no evidence from which a jury could conclude that it was more likely than not that a manhole cover caused the accident.
Well, that's not accurate. It's not a question of a manhole cover. The investigation, let me say this way, on this record, until the autopsy report came back, or the toxicology report came back that he had opiates in the decedent had opiates in his system, and we're not going into whether it's prescribed or not, I'm not going that far here. But okay, then, but until that point, the chief investigator pretty much believed that a cause of the motorcycle spinning out of control was the deteriorated circumference of the manhole cover, and he marked it on the report. It was clear that was where he was going, and when notwithstanding that the plaintiff sort of said, I think I may have spun out because of water, the report pretty much showed that there was no water that was on the roadway. It was dry. Again, with all that kind of information here, why do you think the city should be let out? Because the toxicology report suggested, while he had in his system, we really don't know whether that rendered him, whether that was the sole proximate cause of him losing control of the motorcycle.
Right, because the investigator here reached a preliminary conclusion before he had all the evidence. And I think the most important factor on this isn't so much, I'm not trying to say that he didn't reach that preliminary conclusion and say it was a possibility. It's that it's undisputed that it was based solely on his observation that there was a manhole cover west of where the accident occurred, and where he was informed that the motorcycle came to rest. I mean, he was asked in his deposition, is that the sole basis for your initial conclusion or your initial theory that was the cause? And he said yes. There was never any sort of analysis or any measurements or things. The only measurements that are cited
He's been doing this for 100 years. This is not a guy who just showed up the day before this. He's someone who knows these issues, so he has some level of competence. And if he puts it in his report, how can we grant summary judgment?
Because it wasn't, it's still, even if it's your own witness, it has to be based on a foundation. And
well, I think he said, I've been doing this a long time, right? That's a good foundation.
But just
That's
the
what
observation
a lot
of it.
people get foundations from.
And also, Your Honor, he, in a traffic incident report that he filled out 2 days after the report, he put the location of that manhole cover as approximately 108 feet west of Fifth Avenue. The video, there's video in this case, it doesn't show.
I watched it.
Right, okay.
It's after the accident.
Exactly.
It's impossible to tell.
Well, but Your Honor, I think the point is though, but the camera was also located at the DEP facility, which is also 108 feet west, 708 feet west of Fifth Avenue, and it has a 50-foot field of view. So if in fact he would have, if in fact this manhole cover is where is 708 feet west of Fifth Avenue, you should have seen the decedent contacting it in the video, which
So I think
don't.
fundamentally, and this, somewhat of a function of our unique procedural law, that even the party who's not wouldn't have the burden at trial has at summary judgment the burden to make an affirmative showing through evidence in admissible form of their entitlement to dismissal of the plaintiff's complaint, right? So it's not enough to point to gaps or to say plaintiff won't be able to marshal the evidence. You're in the position of, you move for summary judgment, you have to make that affirmative showing of no negligence or no proximate cause. And so what is the affirmative showing of no negligence and or no proximate?
The affirmative showing is that you could not, we were able to show by basically eliminating and showing that you could not identify a cause without speculation.
Except your own witness gave a cause.
But it still has.
That's a problem for you.
But it still has to be.
Now you don't like what your witness has to say, but.
Well, the witness, the witness based it on essentially without a foundation, was
Well, that's
speculation for the
your
reasons.
view of it, not the plaintiff's view, right? Okay, thank you.
I'm a little reluctant to open my mouth because I think you understand my arguments. Your Honors, I'm here on behalf of the plaintiff respondent. Just a couple of additional things that I'd like to point out. The Detective Passarella's investigation was not limited, and his opinion was not limited to just the location of the manhole cover. They also described as part of the investigation, there were scuff marks on the curb line where the motorcycle had struck the curb line, another thing that they factored in to determine where the accident occurred. That's pages 347 to 348 of the record. They also took measurements. Officer Choi testified about this. That's at page 369 of the record. And something else that I find incredibly interesting is when they prepared the scale diagram of the scene of the accident, they also found an motorcycle oil leak. And that was also part of what they factored in determining what the cause of this accident.
Well, no, it may be a cause of the accident, but they also found that your client had incredible amounts of drugs in his body. That may be a cause of the accident. So I don't think it's fair to say the cause of the accident.
A cause, absolutely, and I'm sorry for misspeaking. However, the interesting thing about when we're talking about the toxicology report, that Detective Passarella admitted that he had no idea about what the behavioral aspect was of these drugs in the plaintiff's system. And in that regard, I want to bring to the court's attention, in my brief, there was a miscite to the record. When I cited to the page of the record where Detective Passarella admitted that he lacked the education, training, and experience to opine as to the behavioral, I cited to page 631. It is actually pages 618 to 619 of the record, and I did let adverse counsel know about that. The other thing that I find very troubling here is they never raised the issue of toxicology below. If they had raised this before the trial court, then we would have had the opportunity to develop this record and to bring in expert testimony to talk about how would these drugs have affected or not affected the plaintiff who was driving. We can't ignore the fact that he drove his motorcycle from upstate New York all the way to the scene of the accident. He was driving the entire time, and even
We don't know that. He could have stopped at a rest stop and taken the drugs. We have no idea. Well, all we know is that when he was tested after he passed, he had a ton of drugs in his body.
And we also know that those drugs were something that he was prescribed.
Oh, absolutely, no doubt. But that doesn't mean that those drugs didn't cause the accident, right?
One of the drugs, well, maybe I missed it. One of the drugs is not even was used. It's really used to treat by veterinarians. I think.
The phenylpropanolamine?
Yeah.
And I'm not 100% sure. In all honesty, I'm familiar with it, using it on my animals. I don't know about the human aspect of it, but that's not something that's part of this record. It wasn't addressed, it wasn't developed. But one of the things that I'm sorry.
Yeah, I was just going to ask you if you wanted to address the newsworthy doctrine that when a plaintiff is deceased and they're not able to tell what happened, there's a different standard.
And I have no problem addressing if you would like me to, which apparently you do, but I think we don't even get there. I think the key thing here is that the defendant, as Justice Haggett pointed out, didn't make their prima facie burden because their own evidence includes the opinion of their own witness, who is their own agent, who is extremely educated, trained, and experienced, and has even been qualified to testify as an accident reconstruction expert. And he turned around and he said, this could be the reason, could be one of the causes of the accident. And if they're saying that in their motion in chief, then they can't negate that claim. But as far as newsworthy, under the Baugh case, which we cited in our papers, Baugh versus Benton, 92 AD3D 133, First Department, 2012, they allowed an accident reconstructionist offered by the plaintiff, based on evidence, measurements, and everything taken at the scene to raise an issue of fact. Here, because of noseworthy, here, we have that on the defendant's side. So we're not turning around and offering our own expert. We're saying, defendant, this is what you testified.
Is it significant, I'm sorry, is it significant that Mr. Passarella closed his investigation based on toxicology?
Well, it's very interesting. One of the things, and I'm glad you bring that up, Your Honor, when counsel talked about the initial, when Detective Passarella said that it was based solely on the location, that was on follow-up number 2, which was the exact same day of the accident. That was before they took the measurements, before they saw the oil leak, before he saw the video, before they took the scale diagram. 6.5 to 7 months later, that's when he turns around, and he did have the toxicology report then, and he did say the reason why he said it was toxicology is because of the level that was in his system, not knowing how it affected him behaviorally, but he still found, after 6.5 to 7 months of investigation, that one of the causes could have been this.
Okay.
We just want to get to a jury. Thank you very much, Your Honor.
Thank you.
Briefly, Your Honors, I just wanted to return for one thing about this being the sole basis for Passarella's initial hypothesis that it was a manhole cover. The oil slick and the scuff marks are irrelevant to that. I mean, I think the testimony was that the scuff marks were from hitting the curb when they came in, and the oil marks don't. Yes, I mean they did observe oil marks and whatnot, but they never link it to saying these oil marks show that you would have hit this manhole cover because of that. What you also don't have is any sort of like, assuming you were going at an appropriate rate of speed or perhaps at different rates of speed, here is how far we think the motorcycle would have ended up so that we can track it back to a particular manhole cover. You just have an observation that there was a manhole cover in the roadway.
But it's not an observation from somebody on the street who has no knowledge of this. This is your guy. This is your guy who goes in to try and figure out how the accident happened. That is a different type of testimony.
Hey, but he hadn't seen the video at that point, and the video shows that. Then
you can walk away from his report all you want now, but it's there.
But the measurement that you want to credit the one thing, but the measurement that he put in 2 days later would put this manhole cover within the field of view of the video camera, and you don't see him contacting this manhole cover in the video.
Okay, thanks very much. Thank you both. Royster versus City of New York. We've got a lot of City of New York cases today. Oops. At least it didn't all spill. At least it didn't spill, right?
Yes, at least it didn't pour all over the table.
Okay, ready?
Clean up.
Yes.
Is this the bottom of the order? I'm
Your
not sure
time
which.
is running. You got to go. Good morning.
Good afternoon. Good afternoon, Your Honor. Stuart Orden on behalf of the plaintiff, and given the limited time, I'm going to focus my attention on, I think, what is a single issue that resolves this entirely, and that is the respondents rely on VTL section 1104 B4, disregarding regulations governing directions of movement or turning in specified conditions. They raise two issues in their brief. They raise one issue I would submit in their motion papers. In the motion papers, it's the impermissibility of making a U-turn, and in their brief, they raise the issue of a sidewalk. They say nothing about it. They simply cite the law that you can't drive on a sidewalk, and they raise, without any facts, the issue that a U-turn was illegal. In both of these, in all of these occasions, they have not submitted any proof or any facts to believe that under the law of the U-turns, which they provided, that this U-turn made by the police on a two-way street where the only lane they are in is closest to the midline because it's one lane in each direction, was illegal. 1160E provides that it's legal if you make it nearest the portion, the marked center line.
Yeah, but I think what they're saying is that you haven't shown, whether they have shown that they can avail themselves of the reckless disregard defense, and whether you've raised an issue of fact as to that defense.
Well, I think
They're clearly doing their job as police officers, so they're entitled to the reckless disregard defense. So the question is, have you raised an issue of fact?
Well, I would respectfully disagree.
Okay.
Under Kabir,
Yeah.
they're not entitled to the reckless defense unless one of those four subsections of 1104B are not complied with. We all agree that the first three are irrelevant. The only ones they raise are the disregard of the rules of the road. If they acted in some manner to cause this accident other than not complying with the rules of the road, then that reckless defense does not apply. And that's Kabir. Plain as, in Kabir, the officer glanced down, and that was the cause of the accident, and that was not something having to do with obeying the rules of the road. In this case, they say the U-turn was illegal, providing no facts whatsoever that the U-turn was illegal and was not in compliance with the rules of the road. In fact, I would argue that it had to be in compliance with the rules of the road, given the definition of 1160E.
Did your client have a helmet on? Let's start with that.
I'm sorry?
Did your client have a helmet on?
He didn't, and he wasn't.
So that's a violation of the rules of the road, right? Was he riding his,
If I may, it's not whether my client violated the rules of the road, it's whether the police violated the rules of the road under 1160.
Whether the police had reason to go after your client.
They had absolutely a reason to go after my client. That's not the question of whether recklessness applies.
But the issue is what kind of recklessness here. Let's do this again. We know that they are an emergency vehicle. We know that they could turn on their lights and sirens.
Absolutely.
They can do that. They claim they saw your client, as you just stated, doing something illegal.
Well, the only
illegality
illegality here is whether it was an ATV, and I'll get to that in a minute if I have time. But the most important salient feature is whether recklessness applies. 1104 doesn't apply.
And he's driving this electric, whatever it is, ATV or a dirt bike or motorcycle onto a roadway.
Well, I will get to the ATV in a moment because I want to be crystal clear about what 1104 of the VTL provides, a heightened standard of liability that you must prove against the police only if they did not comply with the rules of the road. And I'm saying there's no proof submitted except for a statement that they didn't. No proof that they didn't comply with the rules of the road by making a U-turn. The U-turn was legal. So if it was legal, they were compliant with the rules of the road.
Therefore,
1104 doesn't.
Aspect 4 of Kabir doesn't apply.
That's correct. The other thing is they raised for the first time, without any facts, just a statement that driving on a sidewalk is unlawful. Well, there's no testimony. The testimony is replete throughout the record that this was a chase through a park path, which is not a sidewalk, and it was never raised in the motions in the lower court that somehow sidewalk applies, and they have not provided, they have to go forward with facts. They have not provided a single, in fact, Officer Perez distinguishes between sidewalks and a park path in his testimony.
Okay, counsel, but you've now gone over your 5 minutes. You have time on rebuttal.
I'm sorry?
You have time on rebuttal. You've gone over your 5 minutes. Thank you.
Good afternoon, Your Honors. May it please the court, Diana Lawless on behalf of the city. I'm hearing some new stuff here. The undisputed facts here, it's an emergency operation. This is the first time that I'm hearing my adversary say that there was a legal U-turn that started all of this. If you take the plaintiff's testimony, if it matters, you take the plaintiff's testimony, the plaintiff said they were doing stuff on a red light. So they made a...
Did counsel argue below that there was no emergency operation?
I mean, I think he did argue there was no emergency operation, but I didn't hear him ever argue before that it has to do with this U-turn being illegal.
The U-turn, okay.
Right. So, but I mean, okay, the U-turn, his client says it was on the red light. that would make it illegal. But this is also new that I'm hearing.
His client did testify that it was against.
Yeah, his client testifies against the light. So, if we're taking his testimony, this is also new. I'm hearing for the first time that it's legal to ride anything on a park path. It is not legal to ride anything on a park path versus a sidewalk. We cited the statute. His client's testimony, no matter what happened with the U-turn, he said he was pushed onto this park path, fine. But he continued riding down a park path in the middle of the day. People were around. The police were privileged to follow him. And that is why the reckless disregard standard applies. And there is no tribal issue of fact as to reckless disregard. It has to be an intentional act of an unreasonable character in disregard of a known or obvious risk that was so great as to make it highly probable that harm would follow with conscious indifference to the outcome. The only testimony, even from the plaintiff, was he was going, they were behind him, they never touched. The officer's testimony was, I was going slowly. Plaintiff admits it was a narrow path. We were going slowly. And then we win for another reason, which is the cause of the accident. The cause of the accident was the plaintiff, admittedly, being inattentive, turning around, looking back, falling off the motorbike.
He went onto the grass.
He went off, he said he went off to the grass curb. He says he turned around. He turned around to see if they were still there. That's the cause of the accident. There was never a touching of the vehicles. So for either the defense, it's either there's no reckless disregard or because of the cause of the accident. For either reason, summary judgment was properly awarded to the city. Thank you.
Very briefly, the U-turn was addressed in the motion papers and in the brief. I never heard about a sidewalk before. There's nothing to do with the sidewalk here, so they didn't
Let me
violate.
ask you this, if we do find that this was an emergency operation because your client was riding on a automatic, now all of a sudden he
No,
says
I'll
it's
grant you
not
that it was an emergency operation. For the moment, I'll grant you that argument. I don't believe it was.
Okay, so assuming that, have you raised an issue of fact as to reckless disregard?
They don't get to have that. They don't get to get that privilege because they did not fail to comply with the rules of the road. They did.
So if, as your friend said, if they did everything right and they had the lawful right to go after your client, and based on this record, what is the issue of fact? Because according to them, your client caused his own accident.
Well, I'll get that. Then, first of all, then ordinary negligence applies. And we have police officers making a U-turn, cutting my client off, driving him onto the street, 20 miles an hour on a park path with the speed limit is 25 miles an hour for cars in New York.
Well, then you're admitting that they did violate the law.
Who?
The police officers. You can't have it both ways.
No, I'm not admitting that. They weren't speeding. They're allowed to drive on that park path. In fact, the park rules and regulations allowed them to drive on the park path. They were not violating the law. What I'm saying is, under ordinary negligence standards, my client wasn't distracted. If you want to now look at that part of it, my client says he glanced back prudently to make sure he wasn't going to get hit and killed because he didn't know, and he actually had no reason to believe he was being chased down because he's passing cops as he's driving this thing. And all of a sudden, they're chasing someone, not him. He glances back, I think prudently. I think that might be the only prudent action in this entire case, but at least viewing in the light most favorable to my client, he glances back. He never says, there's no testimony that says he was distracted. That's just unfair. He says, I glanced back to make sure I was going to be okay. So if reckless standard does not apply, then the ordinary negligence standard applies, and I think quite clearly they were negligent, but if not, that's a jury question as to whether or not they were negligent or not, and to what degree.
Are you saying that the police hit his bike?
No.
Okay.
No, but he doesn't know he's being chased. So he's trying to avoid getting a police car coming down a path that straddles this path behind him in his own mind, looking for somebody, because that's all he can think of, not him, because nothing happened when he's riding around. So he's cut. His testimony was favorable to him. He cuts off in an emergency reaction to get away from this police, cutting him off, and perhaps they're chasing some other. They end up on the same path that he goes to, which is not a sidewalk. You can look at the testimony of Officer Perez. You can look at the definition. I could provide it to you under the law that a sidewalk is not a park path at all. You can take judicial notice of what a park path is. And
Okay,
they,
counsel, I've let you go for like 5 minutes.
well, I'm answering, I'm trying to answer the question.
Thank you. You've answered it and more.
Thank you,
Thank you
Judge.
so much.
All of you, thank you.
Thank you. Have a good day.
Thank you.